I hereby direct that no officer or agent of the Secret Service shall give testimony to congressional committees concerning matters observed or learned while performing protective functions for the President or in their duties at the White House. This applies to the Senate Select Committee, which is investigating matters relating to the Watergate break-in and the current efforts which I am informed are being made to subpoena President or former members of the White House detail of the Secret Service. You will please communicate this information to the Director of the Secret Service promptly, and either you or he should then personally notify the Chairman of the Senate Select Committee. You should further advise the Chairman that requests for information on procedures in the White House will be given prompt consideration when received by me. Sincerely, Richard Nixon.
In the Senate of the United States, a resolution to establish a select committee of the Senate to conduct an investigation and study of the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons, acting individually or in combination with others, in the presidential election of 1972, or any campaign, canvass, or other activity related to it.
From Washington, NPAC brings you gavel-to-gavel videotape coverage of today's hearings by the Senate Select Committee on Presidential Campaign Activities. Here is NPAC senior correspondent Robert McNeil.
Good evening. The testimony of Watergate bagman Herbert Kalmbach today became almost a sideshow to the struggle between President Nixon and the Irvin Committee over the production of evidence held by the White House. Mr. Nixon stopped the committee from interviewing Secret Service agents, and his spokesman, Ron Ziegler, stalled on whether the White House would give the committee the secret tapes which could implicate or exonerate the president. While all this maneuvering was happening, only partly in public view, the committee tried to keep its attention on Kalmbach, formerly Mr. Nixon's personal attorney. Suddenly this afternoon, his testimony became much more dramatic. The committee revealed that John Ehrlichman had taped a phone conversation, without Kalmbach knowing, just before Kalmbach was to go before the grand jury in April. Kalmbach said he felt as though he'd been kicked in the stomach and accused Ehrlichman and others of using him to pay off the Watergate defendants. Peter Kay tells the story of the other drama, that of the presidential tapes, which we first learned about in surprise testimony yesterday from former White House aide Alexander Butterfield.
The second chapter in the story of the White House tapes began yesterday with the subpoena of 4 Secret Service agents responsible for installing and maintaining recording equipment in presidential offices. Then, in quick succession, the President fired off a letter forbidding Secret Service officers from testifying before congressional committees. The Secret Service men showed up anyway today and appeared briefly before Committee Chairman Sam Ervin, Vice Chairman Howard Baker, and staff members. They met briefly, and then the agents refused to testify. The Watergate Committee went into executive session and decided not to press the matter at this time. Instead, the committee authorized Chairman Ervin to write a letter asking the President to make the tapes and documents relevant to the investigation available. But Presidential Press Secretary Ron Ziegler today reiterated that tapes of presidential conversations as well as documents would not be made available. Rufus Edmiston, the committee's deputy chief counsel, believes that the White House is using the tactic that the tapes really are part of the Secret Service's Presidential Protective Service, and therefore they're off limits to the committee. With the committee's letter, the ball, or rather the tape, is back in the White House court. Tomorrow, Chapter 3.
All right, a recording of a telephone conversation on a White House phone also became a key element in today's examination of Herbert Kalmbach. The attorney representing Kalmbach had notified the committee staff he believed John Ehrlichman had recorded a talk with Kalmbach on April 19th. Late in the day, Senator Ervin pulled out a transcript of the conversation and began asking questions from it. In that exchange, Ehrlichman indicated he had been misled by John Dean. We will have more details on the transcript later in the broadcast.
Here's NPAC's nightly rundown of what you'll be seeing. Kalmbach testified all day. In his first hour of testimony, he explains how he gave $220,000 to Anthony Ulazowitz for the lawyers and families of the Watergate 7. In retrospect, Kalmbach says, the action seems absolutely improper, although it didn't look that way at the time. In the second hour, Chairman Irvin reads the committee's letter to the White House, asking cooperation in securing tapes of presidential conversations. Senator Baker emphasizes that the committee isn't on a fishing expedition. Kalmbach then resumes his testimony, telling how he delivered 3 shipments of money totaling $400,000 in 1970 in New York and California. At that time, he says, he was unaware that it was Stop George Wallace money. Kalmbach continues in the third hour, saying he thought there was an obligation to aid those arrested at Watergate because he assumed someone high in the campaign organization had given the mission a green light. As he became increasingly suspicious of what he was doing, he didn't complain to the president, Kalmbach says, because that would have been presumptuous. In the fourth hour, Kalmbach discusses a tape of a telephone call between himself and John Ehrlichman that was recorded April 19th without his knowledge. He says he felt he had been kicked in the stomach when he realized the recording was made secretly. And in the final hour, Kalmbach says he feels he was used by top White House aides to help obscure their role in the Watergate cover-up. And now Senator Irvin begins today's hearings, and Herbert Kalmbach resumes his testimony.
And the chair recognizes Senator Montoya.
Thank you, Mr. Chairman. Mr. Kalmbach, on yesterday you indicated that you had been called to Washington on June the 28th by Mr. Dean. Mr. Dean has previously given testimony to this before this committee, and I believe he indicated that when he spoke to you on the telephone that he was doing so in behalf of Mr. Haldeman and Mr. Ehrlichman. Is that correct?
Senator, my memory of that telephone conversation is that he used the editorial we. He did not mention anyone's name.
Did he mention any other details with respect to the urgency of the call?
No, sir. He indicated simply that it was a urgent matter that was necessary, that he wanted me to come back to Washington at the first available opportunity, and I think he said by the next available plane.
Did you ask him what he meant by the editorial we in that call?
No, sir, I did not.
Mm-hmm. Did you assume anything when he told you that?
No, sir.
Did you understand him to mean that it might be his associates at the White House when he used the word we?
I wasn't certain, Senator.
But you did leave that night on the 28th and arrived here 6:30 the next morning.
Yes, sir.
And it was then that you met Mr. Dean at the Hay Adams Hotel?
Yes, sir.
And after a little conference there, you proceeded to Lafayette Park, and there you indulged in a little gesturing with him on the horizon and viewing the panorama of Washington.
Yes, sir.
And Mr. Dean testified as follows, and I'll quote from his testimony. It appears on page 3174 of the transcript. Mr. Dean, well, I told him everything that I knew about the case at that time. I told him that I was very concerned that this could lead right to the president. I didn't have any hard facts. I hoped that I was incorrect. I explained to him in full the seriousness of the matter. I relayed to him the fact that some records had been destroyed. I told him virtually everything I knew at that time, and I think there was no doubt in his mind about the sensitivity of the situation. Would you say that this is a correct statement on the part of Mr. Dean?
Senator, my recollection of that conversation was simply that he indicated that he wished me, that use the word again, we, that I was being asked to raise funds for the legal defense of these people and for the support of the families.
Well, did he mention the other ramifications of this particular case?
vis-a-vis possible involvement of the White House? He had already indicated to you that the President might be hurt by this.
No, sir.
He did not. Now, then after this meeting, you proceeded to go back to your hotel and you called Mr. Stans to make available to you as much money as he could. Is that correct?
Yes, sir.
And it was then that Mr. Stans brought to you the sum of $75,100.
Yes, sir.
And after this, you proceeded to call Mr. Ulasevich.
Yes, sir, that's right.
Ulasevich in New York, and he came down and you gave him instructions.
I gave him the funds, Senator, on the 30th, and I'm not certain whether or not I gave him instructions at that time.
Well, when did you receive your instructions from Mr. LaRue?
My memory is that I received instructions from either Mr. Dean or Mr. LaRue within a few days after the 30th, and I think it was by telephone.
Well, then, would you say that Mr. Ulasevich came in to Washington to collect the money on the 30th?
Yes, sir.
And you had talked to Mr. LaRue and to Mr. Dean by that time?
I don't recall that I had talked to Mr. LaRue, Senator, but I had talked with Mr. Dean.
But most of the instructions which you received with respect to the distribution of this money came from Mr. LaRue, actually did. Isn't that correct?
Probably most of them, but I always regarded both Mr. Dean and Mr. LaRue as interchangeable as far as receiving instructions.
Now, why did you pick on Mr. Ulasevich?
Well, Mr. Ulasewicz was, again, as I remember it, when I met with Mr. Dean in the Lafayette Park, and I had asked him if I should give the funds to him, and he indicated no, and then whether or not I should give the funds to Mr. LaRue. It's my memory that at that point he indicated whether or not Mr. Ulasewicz might be the person to handle the distribution of the funds, and I said that would be acceptable to me and that I would trust that man.
Why did you say that? Had you known Mr. Ulasevich?
No, sir, I had not. I had met him 2 or 3 times, but I did know that he had been on assignment, had received instructions from people in the White House for a period of years, and that he was trusted.
You knew that he was a reliable man?
Yes, sir.
And who had he performed assignments for at the White House?
Well, Senator, I'm not certain as to what assignments he had received. I simply know that, and did know at the time, that he had been receiving or handling assignments for the White House and for certain people in the White House over a period of years. I think that probably he was reporting primarily to Mr. Caulfield.
But you didn't know the nature of those assignments?
No, sir, I did not.
How could you determine his reliability then?
Well, simply it was a matter of trust that if he had been performing duties for the White House over a period of years, I was certain that he could be trusted.
Then you got together with Mr. Ulasevich and determined that you would use the telephone booth approach in communications.
Yes, sir.
And you did confine yourself to that kind of communication from then on with him.
Yes, sir. That and the rather infrequent meetings that we had. Yes, sir.
Now, who devised this kind of communication? Did you suggest it, or did he to you?
Well, I think the two of us were talking, and we both understood. I had advised him that this was to be a thoroughly confidential assignment, and I think I wondered to him as to procedures to follow, and we developed those procedures together. I probably wondered aloud about using the telephone booths, and he indicated that that was the procedure, and I think between the two of us we developed the procedures.
Well, were you trying to protect the confidentiality of the assignment, or were you actually afraid that you might be tapped?
Well, sir, I just, we were attempting to make certain as to the confidentiality.
You weren't concerned about being tapped?
Well, yes, sir, I think we were. We didn't know if we would be.
Who do you think might have tapped you?
Just didn't know.
Mm-hmm. Now, then this secrecy continued up until the time you gave Mr. Ulasevich $75,000 at the airport in California. Is that correct?
It continued, Senator, up until through the time that Mr. Ulasevich made the final distribution, and I think that was on September 18th or 19th of 72.
Now, it's been reported that the sum of $450,000 was expended with respect to the Watergate defendants, including their defense and also the cover-up. And I believe you have testified that you were responsible only for approximately $205,000.
Senator, my memory is that approximately $220,000 was the amount that I was that my
Do you know
distribution to Mr. Ulasevich.
Do you know who raised the rest of the money?
No, sir, I do not.
Do you have any quarrel with the figure that GAO has come up with, to wit $450,000?
I have no knowledge, Senator, as to anything other than the $220,000.
Mm-hmm. Now, as you look back in retrospect, Mr. Kalmbach, and in view of the secrecy that was imposed upon you and what you had to go through in order to develop a line of communication in carrying out your mission, do you feel that you proceeded correctly?
In retrospect, Senator, I feel that it was something I should not have been involved in.
Mm-hmm. And at what point did you really become concerned, or did you become concerned at the beginning?
No, sir, I did not at the beginning. But through the month of July, Senator, particularly the middle of July and on, when the entire secrecy procedures began, they did disturb me. It was distasteful to me. That, in conjunction with the press stories that I would read, raised a level of concern with me.
Now, if you had done this differently, would you then have gone to the president, your client and friend, and told him about what was going on?
I'm sorry, Senator.
Acknowledging that you would have done this differently, would you have gone to the president, your client and friend, and told him everything that was going on?
Sir, at the time, I, of course, understood that it was a proper assignment.
Well, you understood that it was proper because you had been assured by Mr. Ehrlichman and Mr. Dean that it was a proper assignment, and that's all you knew about it.
Yes, sir.
Well, you've been practicing law for quite a few years.
Yes, sir.
And in view of the secrecy imposed upon you and the different methods of procedure that you had to resort to, didn't you try to put this as a lawyer in proper context and come up with some grave concern on your part?
No, sir. At the outset, it was a matter of complete and implicit trust in Mr. Dean and then in Mr. Ehrlichman. There was no question in my mind that these men would ask me to do anything improper.
Now, did you feel that it was the proper thing to raise money for these defendants when there were implications not only in the press but also in conversations that money was being used to silence these defendants?
No, sir. I had understood at the time that Mr. Dean made the request of me, and then again when Mr. Ehrlichman confirmed Mr. Dean's authority and the propriety of this assignment, I understood then it was for a proper purpose.
Now, you visited the White House quite often, did you not?
Well, not often, but from time to time, yes, sir.
Well, you had a White House pass.
Yes, sir, I did.
Mm-hmm. And was that in force all the time?
During this period, Senator?
Yes.
Yes, sir, it was.
How long did you have this White House pass, and do you still have it?
I still have it, Senator, and it would be my recollection that I have had the pass since early in 1972.
Mm-hmm. And did you have available to you when you came into town any White House cars to pick you up at the airport?
From time to time, yes, sir.
And they did pick you up?
From time to time, yes, sir.
Mm-hmm. Did you have any direct line to the President from your home? Telephone line?
At one time I did, Senator.
Mm-hmm. And when was that time?
I think that was in 1970, perhaps in 71, but I don't recall with any particularity.
Did you have any conversations through that direct line with the President?
As I have testified, Senator, my recollection is that I have probably talked to the President no more than 4 or 5 times since June of 1969. And I think that I probably talked to him on that particular telephone once or twice.
Mm-hmm. So actually, in view of all these arrangements, I would say that you were a person very close to the President and very interested in his welfare.
Certainly very interested in his welfare, yes, sir.
Now, going into the Jones contribution, which you say was $75,000.
Yes, sir.
And I understand Mr. Jones says it was $50,000. Could there be a mistake here somewhere?
Well, Senator, I can only testify as to my knowledge.
And when you approached Mr. Jones, you approached him as a fundraiser for the President or the President's re-election, did you not?
Yes, sir, for the re-election.
And it was in that context that you went to Mr. Jones.
Yes, sir, it is.
And you told Mr. Jones that this was a very secret thing, secret mission that you were on, and that you needed the money.
Senator, my memory of that meeting with Mr. Jones is that I told him that it was a special assignment. I don't think I said secret assignment. I said special assignment, and the nature of which I could not reveal to him.
Well, when you said that, wouldn't that also mean a secret assignment?
It might, yes, sir.
All right. Now, would you say that when Mr. Jones gave you this money, that in view of your presence there, in view of the fact that he knew you were the President's emissary and that the President was running for re-election, that the money would be used for political purposes?
Yes, sir.
And it was not used for political purposes, was it?
It was used for the legal defense of the defendants and for the family support, yes, sir.
Would you say that this was a violation of the understanding that you thought existed at the time that Mr. Jones turned this money over to you?
Well, at the time, Senator, I told Mr. Jones that it was for a special assignment, and I felt it was not at variance. Now, in retrospect, I do feel it.
Well, would you say that Mr. Jones is entitled to a refund from the committee?
Possibly, Senator. I did tell him it was a special assignment. Whether or not it would involve a refund, I'm not certain.
Now, if you use this money for these defendants, and you were right in so using it, then Mr. Jones is going to be subject to the payment of a gift tax. Wouldn't you say? You're an income tax lawyer and you become well versed with the tax laws of this country.
The question as to the tax, I'm not certain on that point, Senator. It was used for the purpose indicated. There might be a gift tax problem here.
Well, if it was not used for political purposes, and it was used for some other purpose, there is a question there as to whether that transfer of money was exempt from the gift tax.
Yes, sir.
Wouldn't you say that?
Yes, sir.
Mm-hmm. All right. I understand that you didn't call the president because you assumed that the president knew about all these things.
Senator, I did not speak to the president. I spoke to Mr. Dean and Mr. Ehrlichman and had no belief that I should speak to the president about this matter.
Well, you indicated earlier that if you had known what you know now in retrospect, and if you had realized all these things, you certainly would have called the president about all these ramifications.
If I had known at the time when I met with Mr. Dean that he was asking me to do an illegal act, I would have immediately gone to Mr. Ehrlichman and spoken to him about it, because I just could not believe, and it's incomprehensible to me to feel that I could have possibly believed that anyone, Mr. Dean, who was counsel to the president, later Mr. Ehrlichman, the assistant to the president for domestic affairs, could ask the president's personal attorney to do an illegal act.
That is all.
Mr. Kalmbach, who, in reading over your resume, you indicate that you were selected in 1969 as personal counsel to the president.
Yes, sir, that's right.
Now, who selected you as the president's personal counsel?
Mr. Haldeman called me, Senator. I think it was in March of 1969 with that request.
And did you have any discussion with the president at all upon your being hired as the president's personal counsel?
I don't recall a discussion at the outset, Senator. I was reporting on the negotiations for the purchase of the property through Mr. Ehrlichman at that time. I recall a telephone conversation that I had with the president in June of 1969 as to this matter, but not any other conversation prior to the closing of that escrow.
It is not my intention to get into what we'll call the real estate matter here.
Yes, sir.
But as I understand it, then you were selected, or you were chosen by Mr. Haldeman to perform the function of personal counsel to the president.
Mr. Haldeman called me on behalf of the president.
Now, Mr. Kalmbach, I'd like to go to page 3 of your statement, and specifically discuss a sentence which I think is very precise insofar as the words used. That sentence, which states, "My actions immediately following the break-in, which involved the raising of funds to provide for the legal defense of the Watergate defendants and the support of their families, was prompted in the belief that it was proper and necessary to discharge what I assumed to be a moral obligation that had arisen in some manner unknown to me by reason of earlier events.
Yes, sir.
Now, as a paraphrase of that, I'm trying to fathom that sentence. Would this be a proper paraphrase? I assumed I was acting properly based upon an assumption of mine that facts existed, of which facts I had no knowledge?
Senator, I was acting in a certain belief that I was being asked to do a proper assignment, and in my mind, I believed that a moral obligation was felt to exist on the part of someone, and I never knew and do not know on the part of who or more than one person that the money should be given to these people for their legal defense and for the support of their families. And again, Senator, I felt in my own mind that it was a very human thing to do.
Well, now let's just spend a little time, if we can, on the words that you used in that sentence. Now, first of all, what factors prompted you to believe that your conduct was proper and necessary?
The factor, Senator, that I was being asked by the President's counsel, Mr. Dean, to undertake this assignment.
So on that forms the basis for the words proper and necessary. Is that correct?
Yes, sir.
All right. All right. Upon what factors did you assume that there was a moral obligation?
That was my own assumption, Senator, just based on this assignment and the request that had been given to me by Mr. Dean, that there must have been some feeling that there was a moral obligation here to be discharged.
Why would you feel it was a moral obligation? Why not a legal obligation as distinguished from a moral obligation?
Senator, those are just my feelings. It was a moral obligation.
Did you have the feeling that maybe somebody owed somebody something here? Is that another way of phrasing it?
Sir, I know I had the feeling that someone, in some manner, expressly or by reason of some action, had directed these people to go forward on this assignment. And the assignment was, as I say, stupid and illegal, idiotic, but there was a feeling that as long as they'd been directed to undertake this, that there was at least a moral obligation to provide for lawyers for them and for the support of their families.
Well, let's get to another word here where you say to be a moral obligation that arisen in some manner unknown to me by reason of earlier events. Now, as an attorney, are you telling me that you would commence activities that in effect might risk your entire career?
Yes, sir.
On a belief that such activities were proper and necessary to discharge a moral obligation that had arisen in some manner unknown to you?
Yes, sir. Senator, it was a matter of absolute trust in Mr. Dean, and later in Mr. Ehrlichman. I had as I have stated, it's incomprehensible to me, and was at that time, I just didn't think of it, that these men would ask me to do an illegal act.
Well, obviously, you must have made some inquiry as to the earlier events that occurred. I mean, you've stated here today that, this might have been stupid, it might have been illegal, I believe you said, idiotic. I mean, what led you to those conclusions? You must have made some inquiry of the facts before you embarked on this particular course of action.
No, I did not, Senator. I just was plain on its face that it was, one, illegal, two, stupid and idiotic.
But nevertheless, you associated yourself with illegal acts and therefore risked an entire career.
Sir, I associated myself with an assignment to provide funds which I thought was absolutely believed at that time to be the decent thing for these people who I felt a moral obligation was felt to be owed to them, that they'd been told in some manner, and I had no understanding as to how that was done, and I don't have that at this time, but in some manner they were told to go forward.
But then when you responded to Senator Montoya's question that in retrospect, you're not so sure that you did the right thing in retrospect, is that being entirely candid with the committee? Now, didn't you have reservations even then when you were asked to do these acts? It isn't so much a matter of just retrospect now. You had suspicions then.
No, sir, I'm being entirely candid, Senator. I had no reservations and went immediately. I think that the fact that within a matter of minutes after I spoke to Mr. Dean, I'd called Mr. Stans, and within a matter of hours, I had raised $75,100 is indicative of the fact that I had no reservations.
All right, let's get back to this sentence. We're prompted in the belief that it was proper and necessary to discharge what I assume to be a moral obligation. Now, if these activities were believed by you to be proper, why was cash used instead of the normal procedure in handling payments of such amounts?
This was what I was directed to do, Senator.
These activities were believed by you to be proper. Why was it necessary to obtain the services of Anthony Ulasewicz to distribute the monies to the defendants and their attorneys?
Again, this was the procedure that I was directed to follow.
These activities were believed by you to be proper. Why was Mr. Ulasewicz given a code name, Mr. Rivers, and why were Mr. and Mrs. Hunt given the code name of the writer and the writer's wife, and Mr. Haldeman the code name of the brush?
Senator, again, this is just an abundance of caution in the carrying out of the assignment, the confidentiality and the secrecy of the assignment, all of which gave me this ongoing concern.
So again, Mr. Kalmbach, let me
Senator,
return
on
to the question
that,
that I asked earlier. When you made the statement here that in retrospect you felt that it wasn't the proper thing, it's not just in retrospect, was it?
It was absolutely improper. But given my belief at that time that it was, I was certain as to the propriety, I did go forward.
These activities were believed by you to be proper. Then why did Mr. Ulasewicz, at your instructions, distribute the monies to the defendants and their attorneys in luggage lockers at National Airport, and telephone booths, and counters in restaurants, and in trash cans?
Senator, again, this was in the carrying out of this assignment. I spoke to Mr. Ulasewicz. He indicated to me that the manner in which these distributions would be made was something that he would take care of, and it would be better that if I didn't even know about it.
These activities were believed by you to be proper. Then why did you feel compelled in mid-July of 1973 to inquire of John Ehrlichman the propriety of what you were doing?
Sir?
If these activities were believed by you to be proper, then why did you feel compelled in mid-July of 1972, July 26, 1972, to inquire of John Ehrlichman the propriety of what you were doing?
Senator, as I've testified, beginning with the distribution, I think to first Mr. Ulasewicz was to contact Mr. Caddy and then on Mr. O'Brien, Mr. Bittman, and the secrecy involved, primarily the secrecy involved, the press, other factors, gave rise to a degree of concern. And I made up my mind that the only proper thing to do, to make certain as to the authority of Mr. Dean to direct me in this assignment and to make certain as to the propriety, was the reason I asked for the meeting with Mr. Ehrlichman on the 26th.
If these activities were believed by you to be proper, then why did you, at the end of September 72, again on January 19, 73, refuse to take any further part in the distribution of these funds to the defendants and their attorneys?
By that time, Senator, again, after I'd seen Mr. Jones and had been approached by either Mr. Dean or Mr. LaRue to raise additional funds, this level of concern came back on me, and I made up my mind that this was something I would not be involved in.
All right, this is the point that I'm trying to make here today, because I see, Mr. Kalmbach, the picture of an individual that might at the outset have started off without any knowledge, but get some suspicions in fast order along the way. And yet you testified before the committee that here today, as you sit before us in retrospect, these things were wrong. At what point in time did you really say to yourself, you know, I've had it, and I'm just not going to risk my career on what's going on here? At what point in time? It isn't as you sit before us. It must have been some earlier point in time.
Yes, sir.
And when was that?
That was in sometime in latter part of August, in September of 1972, Senator, that I knew that I had reached that point of concern.
And you made no attempt at that moment in time to contact your client, the President of the United States?
No, sir, I did not.
And you've indicated as to the talk that you've had with Mr. Ehrlichman, although that actually took place in July.
Yes, sir.
Did you make any attempt at this point in time in August or September to get the word through to the President via some individual or individuals?
No, I did not, Senator.
You've testified that on July 27, 1972, you called Mr. Jones, the Northrop Corporation, to raise additional funds for the defendants. Now, upon whose authority did you request funds of Mr. Jones at that corporation?
Excuse me, Senator, would you mind repeating that?
You've testified that on July the 27th, 1972, you called Tom Jones at Northrop Corporation to raise additional funds for the defendants. Is that correct?
No, sir. I think that my testimony is that sometime between August 1st and August 5th, that I called Mr. Jones.
All right. In that time period, between August 1st and August the 5th?
Yes, sir.
All right. Now, upon whose authority did you request funds of Mr. Jones at that corporation?
It was on my own authority. I called Mr. Jones to raise funds for this assignment. Now, I had earlier talked to Mr. Ehrlichman, and my recollection is that the time that I met with Mr. Ehrlichman, that I advised him I was going to see Mr. Jones. This was, in fact, the first contributor that I would approach in this assignment, Senator. And Mr. Ehrlichman at that time confirmed, as I've testified, that the assignment was proper, that Mr. Dean did have the authority to direct me in the assignment, and told me to go forward. Now, the statement to me to go forward on this assignment washed away the level of concern that had built up and had occasioned my request for this meeting, and I felt the concern was washed out entirely, and I just went forward based, again, Senator, on absolute trust in this man.
Absolute trust in John Ehrlichman?
Yes, sir.
Well, did you always confer with Mr. Ehrlichman before you solicited the principals of large corporations such as Mr. Jones at Northrop?
No, sir, I did not.
Did you confer with anyone at the White House prior to requesting such donations of corporations?
You mean from Mr. Jones?
Well, from Mr. Jones or any other corporations that you contacted?
No, sir. The other solicitations that I was involved in were solicitations of individuals throughout the 71 period and early 72, Senator.
I beg your pardon. Could you repeat that?
Throughout the 71 period and early 72 for fundraising for the campaign.
And what occasioned you to solicit particular corporations or individuals?
Well, sir, I had known most of these people from earlier years, and I approached them as individuals or as corporate heads, asking that if they would agree to be helpful to the re-election by having such executives within that company as were interested and supportive of the president and the president's programs to agree to contribute towards the re-election financially.
Did you always ask for the donations in cash?
No, sir. I never did that.
Except in the case of Mr. Jones?
Except with Mr. Jones, yes, sir, and that was under that special assignment.
And did Mr. Jones indicate any surprise at all as to the nature of the contribution, it being in cash rather than by check?
No, sir. Again, when I appeared at his office sometime between the 1st and the 5th, and I don't remember when it was, he had the funds in his desk drawer, and they were in the form. It was in the form of cash.
Why Mr. Jones and why the Northrop Corporation? That's what I'm trying to
Mr. Jones,
set right in my own mind.
Again, Mr. Jones had talked to me several weeks before and had indicated to me that he had additional funds or funds available for any special need that I might have or the campaign would have, and that I could call for those funds at any time. And in my own mind, I decided that I would call him, but I wanted to talk to John Ehrlichman beforehand.
But the name of Northrop and Mr. Jones came to you directly, or it came to you through John Ehrlichman?
No, sir, not through John Ehrlichman.
Now, I just have a few more questions. During the course of his testimony, Mr. Mitchell has testified that he wished he'd known of the $1,100,000 surplus left over from the 1968 campaign.
Yes, sir.
Now, I would like your comments about that statement. Do you have any evidence that Mr. Mitchell might have known or did know about the fact that there was a surplus in the 1968 campaign?
Senator, I believe that I had advised Mr. Mitchell at various times that I did have funds under my control.
And this would possibly account for the fact that his law partner, Mr. Evans, was one of the co-trustees of a portion of that money?
Well, Mr. Evans was a signatory on the accounts and on the safe deposit boxes, certain of the accounts.
And it is, to the best of your recollection, there were times when you indicated to Mr. Mitchell that there were such surplus funds from the 68 campaign?
Yes, sir.
I have no further questions, Mr. Chairman.
Before Senator Inouye takes his turn questioning Herbert Kalmbach, we're going to take a short break. Public television's coverage of the Senate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
As we go back to the hearings, President Nixon's personal attorney, Herbert Kalmbach, is still on the witness stand.
Thank you very much. Mr. Kalmbach, you're a senior member of a most prestigious law firm, and among your clients you number some of the nation's corporate giants: Marriott Corporation, United Airlines, Travelers Insurance, MCA, Atlantic Richfield, Dodd Industries, Great Southwest Corporation. Then you have the University of Southern California, the Nixon Foundation, and the Stans Foundation. I gather from this that you're a man whose wisdom and judgment is sought after. You're not a yes man, and you're not a follower. You're a leader. Least of all, I don't suppose you would take orders from a lesser official like John Dean. And I would gather from your success that you must be a great lawyer. And therefore, like Senator White, I find it extremely difficult to believe that you are not aware that illegal activities were being carried out. If a client came to you and related the exact story that is now being related here, and he says, Mr. Kalmbach, should I raise these funds, what would you have advised this client?
If a client had come to me on this situation, which is wholly separate from any situation I could believe that anyone would be faced with, I would have asked him to exercise caution and make inquiries.
Is that the advice you would have given the client?
I would certainly have, on the face of it, I would have asked him to have made inquiries. But in my situation, Senator, I was dealing with the counsel to the President of the United States. It was a matter of absolute trust in the man's integrity and honesty. And again, as I say, it was absolutely inconceivable to me that this man could ask me to do an illegal act, and I've never done an illegal act.
Would you relate to the committee a criminal case relating to the 1962 elections in California and the parties who were involved in this?
Senator, my best recollection on that is that there was a matter that was filed in California. I've done some checking on the pleadings, the judgment, the summation of that was there was an order, I think, to desist in the practice of circulating certain printed literature. I was not aware of this. I was not involved. I did check this out. I was not named in the lawsuit or in the judgment.
Who are those named in the lawsuit?
Senator, without checking on that suit,
I'm certain you know who were involved.
Well, I think it was Mr. Haldeman. I think was one of them. I don't know if the president was named. My recollection is that he was. But without checking on the pleadings itself, I would ask that I be allowed to do so before I made a...
Was Mr. Ehrlichman involved?
I don't recall that his name was involved.
And it is your belief that because of the trustworthiness of Mr. Ehrlichman, you were convinced that everything was proper and legal?
Absolutely.
You were in charge of the surplus 1968 funds, weren't you?
Yes, sir, I was. I was the trustee for these funds, again, Senator, on the basis of trust.
These were cash funds.
Sir, there was $1,098,000 in cash and $570,000 in a checking account.
Isn't it strange that when the campaign closed, the campaign committee for the president indicated that they had a debt? Why wasn't the surplus used to pay the debt?
Senator, I was spoken to by Mr. Stans in mid-January of 1969 and was advised that these funds were surplus. He characterized the funds as primarily from the primary campaign, and I didn't question it.
But you were aware that the Nixon campaign committee of 1968 had declared that they were in debt?
I don't recall that was the case, Senator. It would be my recollection that we finished that campaign in the black.
Evidence seems to indicate that the committee and the Republican Party had incurred some debts in the 68 campaign. However, would you tell us, if you were absolutely certain that the attorneys who had received these funds, the funds that you had raised,
yes, sir,
were certain to declare the receipt of such in their income tax returns?
I have no knowledge, Senator.
Do you think they were going to do that?
Yes, sir.
Then why all the secrecy?
Again, Senator, I was advised by Mr. Dean, and then it was confirmed by Mr. Ehrlichman that this was the procedure to be followed.
If the recipients, the lawyers and their clients,
yes, sir,
were to declare and recognize the receipt of these funds officially in their income tax returns, why all the secrecy in the delivery of these funds?
Well, again, Senator, the actions by these attorneys would be the way I would expect that they would show them. But as to the procedure that I was to follow to get the funds over to these people, there was just no question as to the procedure, and that was the all-encompassing confidentiality, Senator.
So you took the advice and the instructions from Mr. Dean unquestioningly?
Absolutely.
You have indicated that you had a meeting with Mr. Stans, after which you destroyed certain important documents, the reports and the record of contributions. Isn't that so?
Senator, my memory on that is that I gave my reports, what I consider to be original reports, to Mr. Stans in February, March of 1972, and thereafter destroyed what I consider to be personal and supportive documents and papers.
Why did you destroy these papers?
I destroyed them to maintain the absolute confidentiality of my records. Now, there were certain other, checks that were destroyed during this period inadvertently. But what I intended to do was to make certain that all personal and supportive papers that I had, Senator, were destroyed. I didn't know that if I died or if something should happen where these records became public, I felt that I would have breached the confidentiality that I had with the people with whom I had talked, and I have a very strong feeling about if I give a man my word, that's what I feel I should adhere to.
Was it a matter of confidentiality or illegality?
Sir?
Was it illegality or confidentiality, sir?
It was confidentiality.
Were you convinced that the activities in which you were involved were completely legal?
Yes, sir. Absolutely.
Can you advise this committee as to exactly how much all of the attorneys have received?
Sir, in the assignment that I undertook.
Sir. Or their clients, whichever.
Well, sir, my memory is that I caused approximately $220,000 to be given to Mr. Ulasewicz, which was dispersed. Now, as to the total amount that was given to attorneys from the $220,000 plus or minus, I would think it's between $100,000, $130,000 in that area. I'm not certain. Senator, I was advised by Mr. Dean, and then it was confirmed by Mr. Ehrlichman that this was the procedure to be followed.
If the recipients, the lawyers, and their clients,
yes, sir,
were to declare and recognize the receipt of these funds officially in their income tax returns, why all the secrecy in the delivery of these funds?
Well, again, Senator, the actions by these attorneys would be the way I would expect that they would show them. But as to the procedure that I was to follow to get the funds over to these people, there was just no question as to the procedure, and that was the all-encompassing confidentiality, Senator.
So you took the advice and the instructions from Mr. Dean unquestioningly?
Absolutely.
You have indicated that you had a meeting with Mr. Stans, after which you destroyed certain important documents, the reports and the record of contributions. Isn't that so?
Senator, my memory on that is that I gave my reports, what I consider to be original reports, to Mr. Stans in February, March of 1972, and thereafter destroyed what I consider to be personal and supportive documents and papers.
Why did you destroy these papers?
I destroyed them to maintain the absolute confidentiality of my records. Now, there were certain other, checks that were destroyed during this period inadvertently. But what I intended to do was to make certain that all personal and supportive papers that I had, Senator, were destroyed. I didn't know that if I died or if something should happen where these records became public, I felt that I would have breached the confidentiality that I had with the people with whom I had talked, and I have a very strong feeling about if I give a man my word, that's what I feel I should adhere to.
Was it a matter of confidentiality or illegality?
Sir?
Was it illegality or confidentiality, sir?
It was confidentiality.
Were you convinced that the activities in which you were involved were completely legal?
Yes, sir. Absolutely.
Can you advise this committee as to exactly how much all of the attorneys have received?
Sir, in the assignment that I undertook.
Sir. Or their clients, whichever.
Well, sir, my memory is that I caused approximately $220,000 to be given to Mr. Ulasewicz, which was dispersed. Now, as to the total amount that was given to attorneys from the $220,000 plus or minus, I would think it's between $100,000, $130,000 in that area. I'm not certain.
Who were the attorneys who received the money?
Well, I've testified, Senator, that Mr. Bittman received, I believe, $25,000, and that Mrs. Hunt distributed funds to other attorneys.
Who were the other attorneys?
The names, the other attorneys, I think Mr. Rothblatt, I think Mr. Bailey was one of the names.
Will you identify them fully, sir?
I don't know the first name, Senator.
Who is Mr. Bailey?
I think he was the attorney, I think, for Mr. McCord.
What is his first name, sir?
I'm not certain. I'm not certain.
Is it F. Lee Bailey?
I don't know. Just Mr. Bailey. Mr. Rothblatt. Excuse me, Senator. I think Mr. Margulis was another of the attorneys.
Are you certain that these men received these funds?
I'm not certain, but it would be my understanding that they had received funds. But as to the amounts, I just cannot say.
Did you at any time loan a sum of $20,000 to Mr. Ehrlichman from campaign funds?
No, sir. Pardon me. I did loan Mr. Ehrlichman $20,000 from my own funds, not from campaign funds.
In your testimony, you have suggested that you had a meeting with Mr. Dean, at which time he briefed you on how to testify at your FBI interrogation. Is that correct, sir?
I had a meeting with Mr. Dean, Senator. I believe it was on September 29th, prior to my interview by the agents of the FBI. And the reason for that meeting is that I advised, told Mr. Ehrlichman, I believe, that I had been asked to meet with the agents, that in fact I had set that meeting up. I think it was on Labor Day at 10 o'clock in my office in Los Angeles. And Mr. Ehrlichman had indicated that Mr. Dean was conducting an investigation of the so-called Segretti matter, and that I should meet with him and recount in entirety my role with Mr. Segretti, which was that of paying him funds, and to so advise Mr. Dean. I did that.
In your meeting with Mr. Dean, did he suggest that you commit perjury?
No, sir, did not.
In retrospect, sir, as a lawyer, what recommendations would you give this committee as to possible legislation to prevent the reoccurrence of some of the activities in which you were involved?
Well, sir, I would have 2 or 3 suggestions. Number one, I think that without knowing the regulations of the as far as this new law is concerned, the Federal Election Campaign Act, I think it should be made clear that the funds could not be used for this purpose. I think there should be perhaps legislation should be enacted to prohibit the use of cash. Those would be 2 suggestions, Senator.
My final question, sir.
Yes, sir.
At the time you were asked to raise funds for the special assignment, were you aware that the committee to re-elect the president had an overabundance of money?
I was aware that the committee had a surplus, had plus funds, was not running in a negative position. Yes, sir.
Didn't you question the advisability of this special assignment to raise funds when funds were then available?
Well, Senator, again, it gets back to the fact that I had been dealing for at least 2 years, I think, with Mr. Dean in a position of absolute trust. He had been, in fact, the alter ego to the president in matters that I've been dealing with as far as the president's personal work. I was dealing with Mr. Dean on matters involving the foundation. And again, as I say, Senator, when I spoke with Mr. Dean and he made this request to me, it didn't come into my mind that this could be improper. I just felt that I should go forward as a special assignment to raise these funds. This man had, at one time, I recall, towards the first of the year, had been supplying the Finance Committee with opinions as to legality, legal opinions. Again, it was just, there was no question in my mind, Senator, and it was a matter of absolute trust in the character of this person. And I just went forward. And as I say, within a matter of a few minutes, I'd called Mr. Stans for funds.
At no time you questioned the propriety, at no time you questioned the wisdom of Mr. Dean. If Mr. Dean had advised you to take a certain step in relation to one of your clients, let's say that the United Airlines has a case before the CAB and Mr. Dean says you should advise your clients to do such and such, would you, without question, so advise the United Airlines?
No, sir, I would not have. But this was an assignment being given to me by Mr. Dean on behalf of others that he simply named as we. And again, it was a matter of absolute trust that I go forward.
In retrospect, are you now convinced that you were involved in a criminal activity?
In retrospect, now, as testimony, realize, and from what Mr. Dean has testified, that this was improper, an illegal act. It's just as if I've been kicked in the stomach.
Thank you, sir. Thank you very much, Mr. Chairman.
Thank you, Mr. Chairman. Mr. Kalmbach, going back just a minute again to your handling of cash in the 1972 campaign, the turning over of the cash to the committee to re-elect the president, and the destruction of the records.
Yes, sir.
Was there anything illegal about this destruction of records?
Not in my understanding, Senator.
It wasn't the law that prior to April 1972 there was no need to keep any records, cash raised or dispersed or held. Isn't that correct?
Yes, sir, that is my understanding.
Wasn't it a common practice not to keep such records?
Yes, sir, it is.
But even in spite of this, didn't you keep accurate records and turn those over to the committee to re-elect the president? You simply destroyed those copies remaining in your hands. Isn't that correct?
Yes, sir, it is.
May interest you to know, Mr. Kalmbach, that our staff is investigating other campaigns, and there's going to be interesting information about how they handled their own affairs. I think we may find that it was somewhat similar, which is not surprising because that was the practice prior to April 1972.
Yes, sir.
We changed that in the Congress. I take it from your testimony, you certainly are glad we did, and this will make for a much more not only accurate, but let us say responsible and reliable handling of campaign funds. Isn't that your belief?
Absolutely.
In connection with the Segretti matter, I understand from your testimony that you dispersed certain amounts of money to Mr. Segretti. This was done on the orders of whom?
It was done on the orders of Mr. Chapin, Senator.
And what did he tell you in his instructions to you?
This was in either late August or early September of 1971. Mr. Chapin asked me to meet with then Captain Segretti, who was in the Army, asked me to meet with him, to come to an agreement with him as to a compensation level, and reach that agreement and begin dispersing funds to him for activities that he would be performing for the White House.
In this connection, was it your understanding that you were dispersing these funds which were in your control at that time pursuant to the instructions of Mr. Haldeman or under his jurisdiction?
Yes, sir, it was. Mr. Chapin, as I remember our conversation, did not mention Mr. Haldeman, but Mr. Chapin was clearly standing in the shoes of Mr. Haldeman as one of Mr. Haldeman's senior deputies.
During that time frame, as I understand your response, you were dispersing funds out of that resource of cash upon Mr. Haldeman's instructions or under his supervision. Is that correct?
Yes, sir.
Did you ever have any discussion with Mr. Haldeman about this?
About the dispersal of funds?
To Segretti.
I don't recall that I ever did, Senator. My recollection is clear as to my meeting with Mr. Chapin, and my understanding was clear that he was speaking on behalf of Mr. Haldeman, but I don't recall that Mr. Haldeman's name was mentioned.
You had several contacts with Alasowitz during this time of raising money and turning it over to him for dispersal for these Watergate defendants. Did he ever talk to you in any of these conversations about the fact that he was using this money that he obtained from you and paying it over to people for cover-up or hush money or payoffs?
Now, Senator, is this during this assignment period?
Yes.
Sir, he did not use that language. I remember that he had some cautionary words to me which fed this concern that came back on me after I had seen Mr. Jones and which that combined with the secrecy procedures and combined with the press coverage, all of this brought my level of concern to the point where I knew that I would not do more.
What were these terms, cautionary terms, I think you called
them?
Well,
he said this procedure, something to the effect that this procedure is so unusual, or there were, I can't recall the exact language, Senator. It was sufficient for me, with the other factors that were involved, to know that this was something that I would not continue in.
But he never mentioned the words cover-up or anything similar to that that would indicate that it was for cover-up.
No, sir, I don't recall that he did. It was simply cautionary words as to this procedure. He was, after all, a retired New York City police detective and a professional in that field. And these cautionary words, and again, I don't remember exactly what they were, those plus these other factors raised this level of concern, even though I'd seen Mr. Ehrlichman on July 26th. It just came back on me, and I knew at that point that I would not do more.
Did Ulasewicz ever tell you what any of these defendants told him in his contacts with them while he was handling this money and paying them?
Yes, sir, he did.
What did he say?
At various times, he would report discussions that he had with various of these individuals, I think with, primarily, I think with Mrs. Hunt, which I would then relay back to either Mr. Dean or Mr. LaRue, and I think they were primarily had to do with amounts to individuals, that sort of thing.
Do you recall anything besides amounts to individuals?
I don't, Senator.
How many times did you discuss money for these Watergate defendants at the White House?
With Mr. Dean several times, but with only once with Mr. Ehrlichman, and I think a second time when I advised, my memory is that I advised Mr. Ehrlichman of my the fact that I'd received these funds from Mr. Jones in early August.
You described that, of course, already to the committee.
Yes, sir.
Did you ever have any discussions with Mrs. Hunt personally?
Never.
Did you ever discuss, or was there ever any discussion with Mr. Dean, Mr. Haldeman, Mr. Ehrlichman, Mr. Mitchell, Mr. Colson, or anyone else, that this money was being used for cover-up or hush money or payoff money?
No, sir.
That never arose in any of these various meetings that you had?
No, sir.
Mr. Stans indicated when he was here in his testimony that Dean and Ehrlichman had assured you that this request for the $75,100 was for something legal. Do you remember any discussion that you had with Mr. Stans about the legality or the illegality of the $75,100 when you received that from him?
Senator, my memory of my visit with Mr. Stans, first the telephone visit and then my visit with him in the hotel room, was simply that I told him that I had received a very important assignment from someone in authority at the White House, that it was proper, that I could not divulge the nature of the assignment, and that he would have to trust me. And his response was that, Herb, I certainly trust you, and he gave the funds to me without more.
And that was the sum and substance of it?
Yes, sir, that's the sum and substance of that conversation.
Let's go to the meeting in Mr. Dean's office when you and Mr. LaRue and Mr. Dean were there. And as I understand the purpose of this meeting, it was to get instructions from Mr. LaRue on the handling of this money. Was the meeting June 29th?
No, sir. I don't recall any meeting on June 29th. I think the meeting that I recall with particularity would be on July 19th, when I received some $40,000 from Mr. LaRue to be given to Mr. Ulasewicz, with no indication to me as to the source of those funds.
Is that the 18th or the 19th?
My recollection is the 19th.
I'm not trying to trip you up. I just happen to have the 18th here. I may have put it down wrong. Your recollection is the 19th.
Excuse me, Senator.
Counsel says it was the 19th, too.
Yes, sir.
What participation did Mr. Dean take in this meeting?
Well, he was part of the meeting. I think he did. He was on the telephone once or twice, but he was certainly part of the meeting and was aware of what was being discussed, Senator. Now, I'm not clear in my own mind as to whether or not there were instructions given at this meeting, but in all likelihood, instructions were given. But I can't say for certain. But I'm certain that approximately $40,000 was given to me by Mr. LaRue to be given to Mr. Ulasewicz.
Again, you say that he participated in the meeting. Could you be a little more explicit? Because I'm sure you know his recollection is somewhat different.
Well, sir, I know the three of us conversed together in the meeting, so in my view, we were all three at the meeting.
How did the meeting occur? I mean by that, did you arrive first? Who was there when you came into the office? What was said?
I don't remember exactly who was there first. It was, my memory is that we all arrived, Mr. LaRue and I arrived separately. Whether I arrived first or last, I'm not certain, but Mr. Dean, of course, was in the office, and that there was a discussion of these funds that Mr. LaRue had for me, and possibly directions for dispersals to these people by Mr. Ulasewicz, which I would convey along with these funds, which I then took up to New York that night to be given to Mr. Ulasewicz.
Your recollection is it was a meeting between three people, Dean, LaRue, and Kalmbach, a participation of all these three people, and Mr. Dean's non-participation was only when he happened to be on the phone. Is that right?
Yes, sir. That would sum up my memory of that meeting.
Did he have many phone calls? Do you recall?
Oh, I think 2 or 3 throughout this period, and probably the meeting was 30 minutes in length.
There was another meeting in Mr. Dean's office, as I recall, on September the 21st. Same three people. And this meeting, I understand, was to reconcile records. Is that correct?
At that meeting, I went through my records as to funds I had received, the totals, and funds that had been dispersed, again, the totals. And I wanted to make certain that they were in complete agreement with what Mr. LaRue and Mr. Dean understood. And once that I had that confirmation, then I was satisfied and felt that I was discharged formally from this responsibility.
Was this meeting, too, a meeting between these three people?
It's my recollection that it was, yes, sir.
All three participated in it?
That's my recollection, yes, sir.
Why was it held in Mr. Dean's office? Any reason for that?
No, sir. I think it was just probably the most convenient place, rather than for Mr. Dean had many telephone calls all the time. And I think the feeling was that this was the most logical place to meet.
On both these meetings that we have been talking about, do you recall who suggested Mr. Dean's office? Who set up the meeting?
No, sir, I really don't. I'm not certain of that. And I think in view of the fact that I wanted to effect this confirmation of my records, that probably I asked for the meeting. But I don't remember, Senator.
Why did Dean need to be present?
Well, I think the only reason probably was that Mr. Dean was someone that I had been receiving directions from, and I felt it appropriate in case there was any haziness on the part of anybody that all three would be present. That would be my memory of why.
Perhaps another way of putting it, in this particular enterprise that you were engaged in, you thought he was the person who was directing it. Is that fair to say?
Yes, sir. I had the feeling that Mr. Dean was the primary person directing. After all, he'd been the one to see me on the 29th. Mr. LaRue had also given me instructions, but I regarded the two really as interchangeable, but with Mr. Dean probably the primary one.
Do we want to adjourn, Mr. Chairman?
Now you're all finished. We could go till the 5 minutes, but okay. We have two votes coming up in the Senate, one being held now, and we have a vote on the final passage of the bill. The Senate's been considering for about a week or 10 days at 10 minutes to 12. And for that reason, the committee will stand in recess till 2 o'clock.
During this luncheon recess, the committee also held a lengthy executive session, and in a moment, Senator Ervin will report on the committee's efforts to obtain those presidential tapes. Public television coverage of the Senate Watergate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
After almost an hour in an executive session, Senator Ervin brought the committee back to the hearing room and issued a progress report.
The committee will come to order. On this morning, I received a letter dated this morning, that is July the 17th, 1973, from the Honorable George P. Schultz, the Secretary of the Treasury, reading as follows. Dear Mr. Chairman, at the direction of the President, I hereby enclose a letter relative to testimony by the Secret Service to congressional committees. Sincerely yours, George P. Schultz. The letter from the President to Secretary Schultz, which was enclosed in Mr. Schultz's letter to me, reads as follows. The White House, Washington, July 16, 1973. Dear Secretary Schultz, I hereby direct that no officer or agent of the Secret Service shall give testimony to congressional committees concerning matters observed or learned while performing protective functions for the President or in their duties at the White House. This applies to the Senate Select Committee, which is investigating matters relating to the Watergate break-in and the current efforts which I am informed are being made to subpoena present or former members of the White House detail of the Secret Service. You will please communicate this information to the Director of the Secret Service promptly, and either you or he should then personally notify the Chairman of the Senate Select Committee. You should further advise the Chairman that requests for information on procedures in the White House will be given prompt consideration when received by me. Sincerely, Richard Nixon. The committee had subpoenaed certain agents of the Secret Service, and was in the process of, they appeared in obedience to the subpoena. Senator Baker and myself, as members of the committee and members of the committee staff, thereupon undertook to interrogate one of these Secret Service agents, Al Wong. At that time, counsel for the Secretary of the Treasury entered a plea of executive privilege, claiming that under this plea of executive privilege, the witnesses, Mr. Wong and the other Secret Service agents could not be required to testify before the committee. Counsel read copies of the two letters which I have just read to sustain, to set forth and sustain the plea of executive privilege. As a consequence of these letters, Senator Baker and I convened a special executive session of the entire committee, feeling this a matter of such a moment that the entire committee should consider it. After discussion, the committee reached the conclusion that it was not worthwhile at the present time to engage in any controversy with the witnesses on the question whether or not they should be required to testify before the committee. The committee feeling that this was not a matter the witnesses were permitted but them to determine for themselves. But the committee noted the closing sentence in the letter from the President to the Secretary of the Treasury, reading as follows. You should further advise the chairman that requests for information on procedures in the White House will be given prompt consideration when received by me. End of quotation. The committee hopes that the word procedures is much broader than the strict interpretation that word might imply, and is only interested at this stage in getting access and the right to use in the hearings records and tapes in the possession of the White House which are relevant to the matters which the committee is authorized by Senate Resolution number 60 to investigate. And being desirous of adjusting this matter, if possible, on an amicable basis with the White House, the committee decided that the chairman should send a letter to the president asking for his cooperation in making available to the committee records and tapes which are relevant to the matters which the committee is authorized to investigate and relevant to the testimony of witnesses who have appeared before the committee or who are subpoenaed to appear before the committee. And I sincerely hope that this course of action will bear fruit and that we will be able to get access to the records and tapes which we think are relevant and necessary to our investigation in a manner that's satisfactory to everybody concerned.
Mr. Chairman, I'd like to associate myself with your description of the situation as the committee finds it, and to note further that the committee decided, as you very accurately pointed out, that it would serve no immediate purpose to engage in a conflict or controversy with the Secret Service on whether they should or should not disclose information at their disposal, but rather that the decision-making authority resided elsewhere. It is in a spirit of conciliation that we are dispatching a letter which we have now authorized to the President making these requests. One, who is the custodian of the tapes? Two, who has had access to the tapes? Three, how do we go about receiving that information and the tapes as they relate to the lawful inquiry of this committee? Not to a general fishing expedition, not on matters that are clearly protected by executive privilege, such as foreign affairs, internal communications not related to the Watergate situation. But how do we go about getting those relevant portions of the tape? We are, I hope, being both patient and optimistic in taking this course of action instead of pursuing an effort to compel testimony from Secret Service agents, which we might or might not prevail in litigation or otherwise. So I commend the chairman for the action taken, for his description of the situation, and I'm hopeful that we'll have a response very, very promptly, because these hearings are ongoing. It's a matter of monumental importance, and I hope that we can have a discussion very quickly. Now, the last point I'd make, Mr. Chairman, if I may, is the fact that it is public knowledge that a tentative meeting between you and the President had been arranged for. The President's unfortunate illness has intervened to apparently delay that, or at least possibly delay that. And may I say for my part that I hope that that meeting can occur as quickly as possible, or in lieu of that meeting, that at least the principal staff of this committee and principal staff from the White House might immediately begin conversations on how we could gain access to both the documents and the tapes. Thank you, Mr. Chairman.
Any other member of the committee have any observations? If not, resume the interrogation of the witness, and I believe Senator Gurney was interrogating the witness at the time we took a recess.
Thank you, Mr. Chairman. I'll try to be as brief as possible. Mr. Kalmbach, I'd like to go back to the first meeting that you had with Mr. Dean when he instructed you to raise money and then turn it over to Mr. Lazowitz for payment to these defendants. As you undoubtedly know, there's some dispute as to where the meeting took place. Mr. Dean was positive it took place in the Mayflower Hotel. What is your recollection as to where it took place?
My recollection, Senator, is that the meeting on the 29th took place in front of the Hay Adams, and then we met and talked in Lafayette Park. And then my recollection is that on the 30th, which is a Friday morning, that we met in my room at the Statler Hilton.
And you were staying at the Statler Hilton and not the Mayflower?
Yes, sir.
In connection with this testimony, Mr. Chairman, I'd like to present some exhibits here and insert in the record. These exhibits, I'll briefly outline, a letter from the Mayflower, which dated June 27th this year, which simply says that Mr. Kalmbach was not a registered guest between June 1 and July 1, 1972. A letter from the Statler Hilton replying to the subpoena of this committee. The subpoena of this committee for the records of the Statler Hilton. And then the bill of the Statler Hilton, Mr. Kalmbach's bill. And then a registration card plus what appears to be as the imprint of a credit card. I'd simply like to ask the witness if he would turn to the registration card, which is the last exhibit. And do you recognize that printing, it really isn't a signature on the registration card, as your printing?
Yes, sir, it is.
This is what you entered on that card when you registered in at the Statler Hilton?
Yes, sir.
On June 29, 1972?
Yes, sir.
And that is an imprint of your credit card there above the registration card?
Yes, sir.
If those will be admitted in evidence as the proper exhibits.
Identified by Senator Gurney, and the witness will be marked appropriately as exhibits and admitted in the record as such.
Now then, let's go to your fundraising efforts. And let me ask you this question, because there's been some, and will be, I think, some speculation as to whether these were individual contributions or otherwise. When you were soliciting funds at any time, like the one you solicited from Mr. Jones of the Northrop Corporation, did you ever solicit corporate money, or were these always individual solicitations?
I always solicited individuals, Senator, and never asked for corporate funds. I well knew and would never knew that corporate fund contributions were illegal, and I would never ask for corporate funds.
As far as you knew, they were individual funds. That is what you thought you were receiving?
Yes, sir.
In Mr. Stan's May 8th interview with the committee, not his testimony here, his interview, he stated he held daily staff meetings with key associates of the Finance Committee, including Kalmbach, Washburn, Evans, Nunn, and on occasion Reed, Hofgren, and Liddy. At these meetings, did the matter of Watergate ever come up in any respect, either in the planning stage or any other stage?
Senator, pardon me, Senator, would you repeat the question, please?
When Mr. Stans was interviewed by the committee staff on May 8, he said he had daily staff meetings with his key associates of the Finance Committee, which included you, Mr. Kalmbach, Washburn, Evans, Nunn, and on occasion Reed, Hofgren, and Liddy. My question was, did the question of Watergate ever come up in any of these meetings?
No, sir.
I'm talking now, of course, about the planning of the break-in, the bugging, the burglary, and all the rest of the business connected with Watergate?
No, sir. I left the committee on Friday, the 7th of April, and had been in attendance at several staff meetings for the period preceding several weeks, and I recall at no time was any mention made of such a thing. No, sir.
Now let's go to the monies that you gave to Mr. Elasowitz, and as I understand, these were given to him on 4 separate occasions. June the 29th was the first one, and I think you gave him at that time $75,100. Is that correct?
Yes, sir. I think, Senator, that was on June 30th, Friday, June 30th.
June 30th. What instructions did you give Mr. Elasowitz when you turned this money over to him?
Again, my best memory is that I asked Mr. Elasowitz to take the funds and return to New York, return to his home in New York, and that I would be in touch with him as to instructions.
In other words, on June 30th, you did not give him any specific instructions?
I do not recall that, no, sir.
All right. Now, what instructions did you give to him after June 30th about this particular $75,100?
Senator, again, my memory is that sometime immediately after Mr. Elasowitz returned to New York and I returned to California, I received instructions, I think, from Mr. Dean, or it may have been from Mr. LaRue, I'm not certain, asking that I give the instructions to Mr. Elasowitz to contact Mr. Caddy, and I think that those instructions were received within a period of a few days after I returned on the 30th. I thereupon called Mr. Elasowitz at his home in New York and gave him those instructions. He then went to Washington, and there were several calls back and forth, I think, between he and Mr. Caddy, and then he would then call me. I would then contact either Mr. Dean or Mr. LaRue until finally at one point, eventually, it was clear that Mr. Caddy would not receive the funds.
You say he would not receive them?
Yes, sir.
Well, now, what eventually happened to them?
Well, eventually, Senator, I think that an attempt was made to contact Mr. O'Brien with the same result, that Mr. O'Brien would not accept delivery of the funds.
Now, this is an attempt on the part of Mr. Elasowitz.
Yes, sir, at my direction, and I had received the direction from either Mr. Dean or Mr. LaRue.
Go on.
And then, I think it was in the second week of July that eventually a delivery was made of $25,000, I think, to Mr. Bittman by Mr. Elasowitz, again at my direction, and after I had received directions from either Mr. Dean or Mr. LaRue.
In other words, that $25,000 was turned over by either Dean or LaRue instructing you to instruct Elasowitz to give it to Bittman.
Yes, sir, that's right.
Now, that accounts for $25,000. What about the $50,100?
Well, sir, my recollection is that I think Mr. Elasowitz dispersed some $8,000 to Mr. Liddy. I know that I had instructed Mr. Elasowitz to deduct from the funds that I gave to him whatever he needed for his expenses.
Well, how was this $8,000 to Liddy upon your instructions?
Yes, sir, I'm certain that it was.
Received from whom?
From Mr. Dean or Mr. LaRue.
Go on.
And also, $1,000 was, I received $1,000, which I turned over to Mr. Strawn at the White House in response to his request for $1,000.
All right.
About that time, Senator, I received some $40,000 from Mr. LaRue. I think it was on the 19th of July, which I gave to Mr. Elasowitz. And from that time forward, I think my memory is that almost all of the funds went to Mrs. Hunt, with some $30,000 going to Mr. LaRue on or about the 19th or 18th or 19th of September, that when the final payment was made to one payment of some $30,000 to Mr. LaRue, and I think it was some little more than $50,000 to Mrs. Hunt at that time.
Well, if we can go back now, we were down to, we accounted for $34,000 out of the 75.
Yes, sir.
Which would leave $41,000 plus another 40 from LaRue, $81,000. Now, at that point, what happened as far as the instructions to do something with the $81,000? What was the next step?
Senator, throughout this period, several times, I received instructions to instruct Mr. Ulasewicz as to dispersals. And as I say, I think most of those dispersals after mid-July, I think, went to Mrs. Hunt, who in turn distributed funds to various of the defendants and to various of the attorneys involved.
Well, can you give us a little better understanding than that? Now, did you receive word from Dean LaRue to give X amount to Mrs. Hunt?
Yes, sir. I remember that I was told from time to time to give X amount to Mrs. Hunt.
Do you remember what those amounts were and when?
No, sir, but in reconstructing this history, in trying to develop what the amounts were and to whom the funds went, my memory is that approximately $150,000 or thereabouts went to Mrs. Hunt, out of which certain of the attorneys were paid and various of the defendants. Beyond that $150,000, there was $30,000 that was given to Mr. LaRue and the final dispersal. $25,000 was given to Mr. Bittman. I think $8,000 was given to Mr. Liddy, as I remember it. $1,000 to Mr. Ulasewicz, and $1,000 which I retained and delivered to Mr. Strawn. Now, if that total is approximately $220,000.
And the amount, as I recall, was $219,000.
Yes, sir.
So then, as I understand it, this rather large amount to Mrs. Hunt, approximately $150,000, was paid from time to time, and you don't actually recall the specific dates and the amounts?
No, sir, I do not. I don't recall. I recall with particularity the dates when I received funds, but I don't recall with anything like particularity as to the dates that I called Mr. Ulasewicz or when instructions were given to Mr. Ulasewicz to make these dispersals. And as I say, after mid-July, I think most of all of the money went to Mrs. Hunt, who in turn distributed the funds to various attorneys and other defendants, plus the $30,000 that went to Mr. LaRue in September.
What is your recollection of the instructions that you were receiving from Mr. Dean or Mr. LaRue at this time, so far as payments to Mrs. Hunt are concerned?
Well, the instructions, as I remember it, were to give her funds for attorneys, and I recall the names of the attorneys over and above Mr. Bittman, Mr. Rothblatt, I think Mr. Bailey, and Mr. Maroulis. Plus, there were attorneys but I do not remember the names of attorneys for other of the defendants. And a lesser amount was given to those attorneys, some 3 attorneys for 3 of the defendants.
Who did the instructions come mainly from, Mr. Dean or Mr. LaRue? You
Well,
recall?
initially, it's my recollection that they came primarily from Mr. Dean, but shortly thereafter, into the period, it began to become more from Mr. LaRue, although I always, again, had it interchangeable, Senator.
In the raising of the money, as I understand it, you received 4 amounts here that totaled to $219,000. Where did most of the pressure come from to raise this money? Do you recall that? From whom?
No, sir. I was given my instructions again by either Mr. Dean or Mr. LaRue, and then I recall that Mr. Ulasewicz would receive communications from the people that he was talking to, and primarily Mrs. Hunt, which I would relay back to these people, and then I would relay again back down. After I received my instructions, I would then call Mr. Ulasewicz.
Just one final question, Mr. Kalmbach. Did you have any discussions following the break-in of Watergate down to now with the President?
No,
about
sir.
Watergate?
No, sir. Not at any time.
Neither on the phone or in person?
No, sir.
That's all, Mr. Chairman.
Senator Talmadge.
Thank you, Mr. Chairman. Mr. Kalmbach, I want to get into an area that you have not testified on, that we've had reports in the press about it. Are you familiar with funds going into the state of Alabama during the 1970 election?
Well, Senator, I'm familiar with funds that I dispersed in 1970 under instructions. At that time, I had no knowledge as to where the ultimate distributees would be.
Will you tell us about that fund, please?
Yes, sir. During the 1970 period, I was raising funds for in the senatorial races, and also I was directed by Mr. Higbee on 3 different occasions to disperse funds out of trust funds that I had under my control. I recall that there was a call that Mr. Higbee made to me, and I think it was in late March of 1970, directing that I disperse $100,000 to someone at there in New York. I took these funds from the box, the safe deposit box at the Chase Manhattan Bank in New York, and delivered them to an individual at the Sherry Netherlands Hotel in New York.
Who was the individual?
I did not know his name and do not know him.
How did you know you gave the $100,000 to the right man?
I was advised at a later date that it was that I had given the funds to the right person.
Who gave you the instructions as to whom to meet and where?
I talked to Mr. Higbee, and he instructed me, and I said that I would deliver the funds at the Sherry Netherlands Hotel. And a individual then came up to me, and the identification was proper, and I gave him... Was
it password?
No, sir, I don't recall the procedure now, but it was definite that it was the man.
You didn't walk into the lobby and give the first $100,000 to the first man you saw, did you?
No, sir.
Well, what was the arrangement whereby you could make the proper contact?
I don't recall the specific arrangement, Senator. It was simply that I was in the lobby, and I think I was in a particular color suit, and he came up to me and identified himself as being from someplace, and I don't recall where it was.
Did he have a southern drawl?
I don't remember it, no, sir.
You didn't hear his voice?
I heard his voice, but it was not distinctive.
Well, what was the signal as to how he could identify himself to you to receive the $100,000?
I think that the signal was that he asked me if I was, forget whether I was from some state, and I replied yes or something, and that was sufficient, but I don't recall the exact procedure.
Did you have a code name?
No, sir, I did not.
Did he have one?
No, sir, I don't
You know
recall
what
it.
purpose of that money was for?
I did not.
Did you have any suspicions?
No, sir, I did not.
You didn't think they were going to take it somewhere and burn it up, did you?
No, sir.
Now, tell us about the next contribution that you made and the circumstances thereof. That was the first $100,000.
Yes, sir.
Where did that money come from?
It was funds that I held in trust that Mr. Stans had entrusted to me.
Was that leftover money from the '68 campaign?
Yes, sir.
Proceed, please.
Then, I think within a month, Senator, I was again asked to disperse $200,000 following the same procedure.
Did Mr. Higbee also request you the second time?
That's correct.
All right, go ahead.
And my recollection is that I asked one of the signatories on the box, Mr. France Rain, to take the funds to the Sherry Netherlands Hotel and disperse to an individual, which he did.
Was it the same individual?
I do not know.
You didn't deliver the second $100,000?
No, sir, I did not.
You just made it available?
Yes, sir.
All right, that's $300,000. Now tell us about the next amount.
Then finally there was a third communication, again, I think it was from Mr. Higbee, directing that another $100,000 be dispersed in the same manner, although at this time I was asked to disperse to an individual. Trust funds that I had under my control. I recall that there was a call that Mr. Higbee made to me, and I think it was in late March of 1970, directing that I disperse $100,000 to someone at there in New York. I took these funds from the box, the safe deposit box at the Chase Manhattan Bank in New York, and deliver them to an individual at the Sherry Netherlands Hotel in New York.
Who was the individual?
I did not know his name and do not know him.
How did you know you gave the $100,000 to the right man?
I was advised at a later date that it was that I had given the funds to the right person.
Who gave you the instructions as to whom to meet and where?
I talked to Mr. Higbee, and he instructed me, and I said that I would deliver the funds at the Sherry Netherlands Hotel. And a individual then came up to me, and the identification was proper, and I gave him the
password?
No, sir, I don't recall the procedure now, but it was definite that it was the man.
You didn't walk into the lobby and give the first $100,000 to the first man you saw, did you?
No, sir.
Well, what was the arrangement whereby you could make the proper contact?
I don't recall the specific arrangement, Senator. It was simply that I was in the lobby, and I think I was in a particular color suit, and he came up to me and identified himself as being from someplace, and I don't recall where it was.
Did he have a southern drawl?
I don't remember. No, sir.
You didn't hear his voice?
I heard his voice, but it was not distinctive.
Well, what was the signal as to how he could identify himself to you to receive the $100,000?
I think that the signal was that he asked me if I was, forget whether I was from some state, and I replied yes or something, and that was sufficient, but I don't recall the exact procedure.
Did you have a code name?
No, sir, I did not.
Did he have one?
No, sir, I don't recall it.
You know what purpose of that money was for?
I did not.
Did you have any suspicions?
No, sir, I did not.
You didn't think they were going to take it somewhere and burn it up, did you?
No, sir.
Now, tell us about the next contribution that you made and the circumstances thereof. That was the first $100,000.
Yes, sir.
Where did that money come from?
It was funds that I held in trust that Mr. Stans had entrusted to me.
Was that leftover money from the '68 campaign?
Yes, sir.
Proceed, please.
Then, I think within a month, Senator, I was again asked to disperse $200,000 following the same procedure.
Did Mr. Higbee also request you the second time?
That's correct.
All right, go ahead.
And my recollection is that I asked one of the signatories on the box, Mr. France Rain, to take the funds to the Sherry Netherlands Hotel and dispersed to an individual, which he did.
Was it the same individual?
I do not know.
You didn't deliver the second $100,000?
No, sir, I did not.
You just made it available?
Yes, sir.
All right, that's $300,000. Now tell us about the next amount.
Then finally there was a third communication, again, I think it was from Mr. Higbee, directing that another $100,000 be dispersed in the same manner, although at this time I was asked to disperse to an individual in Los Angeles in the lobby of the Bank of California building on Flower and 6th Street.
You delivered $200,000 and an agent delivered the other $200,000.
That's correct.
And your directions, your instructions to deliver the money came from Higbee twice, and who the third time?
From Mr. Higbee the third time.
All 3 times?
Yes, sir.
Did you have any suspicion as to where that money was going?
No, sir, I did not. I made the assumption without knowing that it was going into campaigns, but I did not know which campaign.
What was your assumption?
That it was going into various of the campaigns, but I did not know which.
What campaigns?
Well, the various of the campaigns in the 1970 election year.
More than one campaign or just one?
Well, I think I made the assumption that it was going into more than one.
Wasn't that in fact the money that was used to try to defeat Governor Wallace in Alabama in 1970?
Well, Senator, I've never known this to be a fact. I think subsequent to the dispersals, I heard comments to the effect that part or all of those funds did in fact go to that campaign. But I did not know at the time, and the only evidence or indication that I've had subsequent was just various comments.
A man of your intelligence and ability and background certainly wouldn't be in the business of just walking up to strangers in hotels and giving them $400,000 for nothing, would you?
No, sir.
You suspected that it was going to stop Governor Wallace in Alabama, did you not?
I did not at that time,
But
Senator.
you subsequently suspected that.
Yes, sir.
Do you know that of your own knowledge?
I don't know it as a fact, Senator.
It's common knowledge, though, in circles that handle that money, is it not, Mr. Kalmbach?
I beg your pardon, Senator?
It's common knowledge in circles that raised the money and dispensed it, is it not?
Well, I think there's a belief that part or all of it did go to that campaign. But again, Senator, I would not have the certainty that that is true.
Now, there's one thing I didn't understand from your testimony to date. Who made the decision as to how much of this money that would go to these defendants and their lawyers?
Well, the decision, as I remember it, Senator, was always handed to me either by Mr. Dean or Mr. LaRue, and then it would be passed from me to Mr. Ulasewicz onto these individuals. I think Mr. Ulasewicz received certain communications, again, that he relayed to me and I relayed on up, which would perhaps was confirmed as to suggestions, but there was no negotiating at all on the part of either Mr. Ulasewicz or myself.
Your answer then is Mr. Dean or Mr. LaRue determined how much each of these people and their lawyers would get?
Yes, sir, ultimately.
Did any of the attorneys that money was delivered to ever indicate what source it came from, or wonder what source it came from, or make inquiries about what source it came from?
I don't recall that any did. No, sir.
It'd be strange to you as a lawyer if some intermediary came into your office and gave you $25,000 and never indicated the source, wouldn't it?
Yes, sir, it would.
Wouldn't you have some deep, dark suspicion about it and want to have more knowledge about it?
I would be suspicious, yes, sir.
Now, you stated yesterday that you believe that the payment plan...
Incidentally, Senator, I want to add that I had the feeling that these men were anticipating a call from Mr. Ulasewicz, but I had no knowledge as to how or who had communicated with, for example, Mr. Bittman. I had no knowledge as to how or who had communicated with him so that he was anticipating a call from Mr. Ulasewicz. That was handled, I think.
What you're saying is delivery of the money didn't take the lawyers by surprise, is that
No,
it?
sir, it did not. Or the calls did not.
You stated yesterday that you believed that this payment plan was so important because it came from Mr. Dean, the President's personal counsel. Did you, because of that, suspect that the President himself might have approved it?
No, sir.
You did not?
No, sir.
You just took it at face value because the President's counsel himself indicated that to you?
Again, Senator, here was a man that I'd been dealing with for a year and a half, or 2 years at that time, a man in whom I had absolute and complete trust. He was standing really in the shoes of the President on the President's legal work that my partner and I would be talking to him about. It was again without, my own nature is that I trust my friends and trust my partners, and I had absolute trust in this man. And when he made this request of me, I didn't hesitate.
Well, you yourself was the President's personal counsel. You represented him in personal matters.
Yes, sir.
Mr. Dean represented him, I presume, primarily in official matters, did he not?
Yes, sir.
Well, didn't you feel free as the President's personal lawyer to check it out with him at that time?
Senator, as I think I've testified, I think I've met with the President not more than 4 or 5 times. Since 1969, he has such a very busy schedule. That,
I would hope my personal lawyer would feel perfectly free to communicate with me at any time, and I'm quite sure that he would, particularly if a matter arose that might be suspicious affecting my interest.
Yes, sir.
Now, you testified, I believe, that you finally became concerned about the James Bond nature of all of these affairs, and finally went to Mr. Ehrlichman to determine Mr. Dean's authority. Is that not correct?
Yes, sir, and to confirm the propriety.
And he told you that Mr. Dean did have authority to do so. Now, you met with Mr. Ehrlichman a number of times, I believe, in July, did you not?
I think once or twice in addition to that meeting, but I'm not certain as to that, Senator.
I believe in your testimony and depositions in the suit filed by the Democratic Committee, you had dinner with Mr. Ehrlichman in California, as I recall, July the 6th. You also, I believe, stated that you had met with Mr. Ehrlichman on July the 14th. And you finally, I believe, met with Mr. Ehrlichman on July the 26th, 1972, in his office to confirm the authority of Mr. Dean to authorize the payments.
Yes, sir.
And you did meet with Mr. Ehrlichman on those 3 occasions, did you not?
Well, Senator, I'm not certain on the first meeting if that was a large dinner meeting or whether I was with him alone. I'm just not certain of that.
I believe I'm informed by a member of the staff that the first meeting, which occurred on July the 6th, occurred on your calendar, so that meeting might have been in your own office. Do you recall such a meeting?
Sir?
Do you recall such a meeting in your own office on July the 6th in California?
No, sir, but it could have happened. I'm not. I don't recall.
Now, did you believe or have reason to believe, because Mr. Ehrlichman told you to go ahead with these matters, that the message might have been relayed by the President to Mr. Ehrlichman?
I think I made the assumption that it had been.
Did the President ever speak to you after the press had released an account of the stories involving you with Mr. Segretti in September of last year to ask you what had occurred?
No, sir.
I believe you stopped raising money for the defendants in September 1972, did you not?
Yes, sir.
Did you stop these fundraising efforts because your name had been publicly associated in connection with Donald Segretti?
No, sir. I think that that was perhaps part of the, but the primary concern that had fed my earlier concern and came back on me, Senator, was the secrecy procedures. The fact that Mr. Segretti was talked to by the Bureau, by the FBI on the Segretti matter, was something that I had given him funds from about the 1st of October, last of September, to the 1st of February, never knowing what he was involved in, and suddenly these stories began coming out, and I didn't, it was something that I had concern about.
Did you notify anyone at that time that you thought that fundraising and distribution was improper?
Sir?
Did you notify anyone at that time that it was your conclusion that this fundraising was improper?
For this assignment?
Payment of such affairs as Segretti, the defendants, their living expenses, their bail, their lawyers' fees, and one thing and another?
I indicated, Senator, that I would not be involved in this.
And that was the time you stopped raising money for that purpose?
Yes, sir.
Did the President call you after the election in November 1972?
Yes, sir, he did.
That was after you'd raised funds for payments to these defendants and other purposes, was it not?
It was, and it was after the election and after I had raised a substantial amount of money for the re-election campaign beginning back in November of 1970, Senator.
What was discussed in that conversation relating to Watergate?
Nothing.
Nothing. Why didn't you mention to the President at that time your fundraising activities?
I had no reason to, Senator. He called me to thank me for all the help that I'd been in the re-election campaign. It was something following the election. It was something that was very thoughtful of him to do. And
Don't you think a president's personal lawyer who had become so suspicious of what he was doing in the campaign that he quit, terminated his activities, that would have been a good time for him to inform the president that these things have occurred, Mr. President, I think you ought to know about them?
Senator, when in my dealings, I was dealing with Mr. Dean and Mr. Ehrlichman, two men that the President had implicit trust in, and it was my belief that any concern I had was sufficient for me to not go forward, but it was just that feeling. I didn't have any belief that in fact this was improper, but I had sufficient concern about the procedures that I was following, distasteful, that I didn't want to be involved at all. And
you didn't think you were performing a service for Mr. Dean, did you? You thought you were performing a service for the President of the United States, didn't you?
Senator, I thought I was performing a service for the people that Mr. Dean referred to as we.
Who do you think were we?
I thought probably he was talking about the senior people at the committee to re-elect and possibly some of the people at the White House. But I didn't have any...
See if I can put that in perspective now. You thought all of these people that you were rendering a service for.
Yes, sir.
On the same team, and all of you were rendering a service for the President of the United States. Isn't that true?
Well, I thought that I was being helpful on this assignment.
You wouldn't go all over the country giving away hundreds of thousands of dollars in cash and engaging in surreptitious activities for some clerk in the White House, would you?
No, sir.
I don't blame you, sir. Now, did Mr. Dean call you in California in January 1973 and urge you to see if you could talk Mr. Magruder out of running for elective office in California?
I think that he did talk to me about Mr. Magruder, who was thinking of coming back to California, and his plans were not fixed.
Did you talk to Mr. Magruder?
Yes, sir, I did.
Did you dissuade him?
No, sir, I don't recall that I dissuaded him.
Did you urge him to run or not to run?
I didn't. It was my recollection of that meeting, Senator, was simply that Mr. Magruder was talking to some people in California to make up his mind at a later date as to whether to return to California to seek office or not. And I didn't encourage him one way or the other.
You didn't execute the Dean mission that time then, did you?
I don't recall that there was a specific mission in that sense.
Didn't Mr. Dean urge you to try to dissuade Mr. Magruder from seeking public office in the state of California?
Well, Senator, I don't recall that I understood it that way. I did meet with Mr. Magruder, and I think that he just had talked to many people in California, and he was going back to Washington. I did not know whether he was planning to run for office or not.
Did you meet with him at Dean's request or not?
No, sir.
You did not?
No, sir.
So you deny Mr. Dean's statement?
Well, I don't deny that Mr. Dean called me. I'm not certain as to what was said or can't recall it specifically, Senator, but I don't recall that I spoke to Mr. Magruder to dissuade him from running for office.
Now, let's see who all raised money to the best of your knowledge for these defendants. What role did Mr. Stans play in that?
no role to my knowledge other than giving me $75,100 on the 29th at my request, and at which time I would not tell him of the purpose of this assignment.
Other than that, you know of nothing.
That is correct.
Mr. Haldeman.
Nothing to my knowledge.
Mr. Ehrlichman.
Mr. Ehrlichman I met with, for the first time I discussed this with Mr. Ehrlichman on July 26th, and then my memory is that I confirmed that I had received an additional $75,000 from Mr. Jones in early August when I met with Mr. Ehrlichman.
Mr. Colson.
Not at all.
Mr. Mitchell.
I don't recall ever talking to Mr. Mitchell about this except at the meeting in his office on Friday, the 19th of January, 1973.
That was when he declined to raise funds for that purpose.
Sir?
That was when Mr. Mitchell specifically declined to raise money for that purpose.
No, sir. That was when I had been asked by Mr. Dean to come over to Mr. Mitchell's office, and Mr. Dean raised the subject then, and I said I would not do more and excuse myself.
There was one thing that disturbed me in your statement, and Senator Wyckoff pursued it at some length, and I still couldn't get a conclusive answer.
Yes, sir.
What, Mr. Kalmbach, made you think that there was any moral obligation to raise funds and pay lawyers and support their families and bail money for convicted burglars?
Senator, it was a feeling that I had at the time. I know that I felt that in some way, and I had no understanding as to how it had happened, but I had the feeling that in some way someone in authority had pressed the green light and had encouraged these people to go forward. Now, on a very stupid, idiotic assignment, an illegal act. I had the feeling that someone in authority, someone or more, felt that at the least that could be done for these people who had been perhaps discharged or followed an assignment was to provide them with lawyers and to provide support for their families. And I felt that that is under the general head of a moral obligation.
Let me see if I can simplify it for you and see if you agree. You thought they were part of the common team that you were playing on, is that right?
Well, I felt that they were a team of individuals who had been asked to do this and improperly, and that the human thing to do, the decent thing to do, is to at least provide them with legal help and provide them with support for their families.
Well, if an ordinary burglar had broken in the Mayflower Hotel, you wouldn't feel that way about him, would you?
No, sir.
Was it because these people were on the same team and engaged in a common effort that you felt that you had a moral obligation to support them?
Senator, I had no knowledge at all in any way, shape, or form as to the Watergate break-in. Yeah. But I felt at the time that I was talked to by Mr. Dean that someone in authority must have had the feeling that the least that could be done for these people who I felt had been ordered to go about this assignment is to...
Did Mr. Dean tell you, these are our boys, we got them into it, we got to help them? Is that what you're trying to tell me?
No, sir, I don't remember that conversation.
Well, I don't see how you could reach the conclusion you have unless you thought that they were on the same team, trying to achieve the same purpose, and taking orders from the same captain.
Well, I think that in the sense that they were receiving instructions from someone in authority, that they were on the same team. But to the extent that they were directed to do something unlawful, that is beyond me. But I do feel, Senator, that feeling must have been on the part of someone in authority that the least that could be done for these people is to give them this assistance.
Thank you, Mr. Kalmbach. I congratulate you on your testimony. I know some of these things have been difficult for you as one of the leading lawyers in the country. And I compliment you on your candor, sir.
Thank you, sir.
No further questions, Mr. Chairman.
Before Senator Baker probes the Kalmbach relationship with the White House, we're going to take a pause. Public television's coverage of the Watergate hearings will continue after station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
As we go back to the hearings now, Senator Baker is questioning Herbert Kalmbach.
Mr. Chairman, thank you very much. Mr. Kalmbach, I'm not quite sure I fully understand the scope and consequence of this project, as you say. My first impression was that the project, and I believe that's our assignment,
yes,
is
sir,
the way you put it, that this assignment was to raise money for, in effect, a defense fund for these
yes, sir,
defendants. But in trying to reconstruct your testimony and the other information that I have, you raised $75,000, I believe, from Mr. Jones with the Northrop Company. But I have no notes or recollection that you raised any other money. The rest of it was given to you by LaRue or Stans or someone else.
Yes, sir. I think, Senator, that I did solicit Mr. Stans.
Yeah, well, Mr. Stans, however, was part of the organization. That is, he was the general finance chairman for the campaign. So it
yes,
wasn't a solicitation in the sense that it wasn't a gift, but rather calling on another part of the organization for funds.
Yes, sir.
Well, you see, I'm not quite clear then what the assignment was. the $75,000 obviously isn't inconsequential. That's a very substantial amount. But $144,000 was derived from internal sources, so to speak.
Yes, sir.
But why weren't those funds given directly to the parties involved instead of being channeled through you or flown to New York or delivered in a hotel lobby or the like?
Well, Senator, I don't know. Now in retrospect, I believe that there was a conscious attempt to separate by 2 or 3 or 4 people the actual payment to these individuals. I can't. Your question is apt, and there was the only time that I solicited funds from an outside contributor was from Mr. Jones. Yes, sir.
If you don't mind, and without burdening this record too extensively, would you tell me once again how you were initially contacted, by whom, and given this assignment?
Yes, sir. I was called on early or mid-afternoon California time on the 28th of June by Mr. Dean. In response to Mr. Dean's request that I come back to Washington for a very important assignment on the first available plane, I took a flight 10:15, 10:30 that night from Los Angeles to Washington.
Stop. Did Mr. Dean impart to you any information as to the nature of the assignment?
No, sir, he did not.
Did he indicate that it was a fundraising activity?
No, sir, he did not.
Or a legal activity?
No, sir.
Go ahead, sir.
Upon arrival in Washington, I went to the Statler Hilton, checked in, and by the time I'd changed and breakfast and all, it was probably 9 o'clock. My memory then is that I then called Mr. Dean in his office in the executive office building, telling Mr. Dean that I was here in Washington, that I could come over to his office to meet with him, to discuss whatever he had in mind. He then told me that, no, you say you're at the Statler Hilton. I'm here in the executive office building. The Hay Adams is about halfway. Why don't we both walk over and meet in front of the Hay Adams?
Did that strike you as an odd request?
Well, it was the first time, Senator, that he'd ever made such a request to me to meet other than in his office. I don't remember ever meeting in front of a hotel or in a park before.
I'm not trying to lead you into entrapment. I'm just trying to get the feel for the circumstance and your reaction to it, and very frankly to establish at what point you came to have concern and apprehension about this.
Yes, sir.
But in any event, that was unusual, at least to the extent that you'd never done it before. Did it raise any other concerns in your mind?
No, not really. I just felt that he decided he wanted to stretch and walk, and it didn't strike me as odd beyond that.
All right, sir.
I didn't have any idea what he wanted to talk about.
All right.
I then went to over in front of the Hay Adams. I think I was standing in front of that church on the corner, across from the Hay Adams, and noticed Mr. Dean walking up through the park. I then, the light with me, I crossed over and met him as he came up through the park. And I think I suggested that we might go over to the Hay Adams for some coffee. He then said, as I recall, that no, let's just walk in the park and talk. We walked over and for a ways, and then stopped by a bench and talked. And it was at that point that he got into this assignment, saying that we would like to have you undertake the assignment to raise funds for these people who were involved in this Watergate break-in, raising funds so that they will have legal help and raising funds for the support of their families. And he said it's an absolutely important assignment, and it's something we are asking you to take on.
Mr. Kalmbach, did you ask him who we was or we were?
No, sir, I did not.
Did the thought occur to you?
It must not have, or I would have asked him, but I just felt that he was saying we, and just, again, in the context, Senator, of my association with this man over the prior 2 years, it was simply enough that he asked this.
Did the thought occur to you that there might be something odd or strange about a White House involvement or the involvement of a principal staff person, in this case Mr. Dean, in this fundraising effort for defendants who'd received prominent publicity at that time and obviously were going to be charged with a serious offense? Did that raise any ripples of concern?
Again, Senator, it did not. I knew that Mr. Dean had been very involved in matters involving the committee to re-elect, and he was probably wearing several hats, but I know that he had that association with the committee to re-elect. I felt that here was a man who I had this trust in, asking me to take on this assignment, and I did not question it. It would have been inconceivable, as I've said, Senator, for me to have believed that this man would ask me to do something illegal.
That gets us to the point I'd really like to inquire about, Mr. Kalmbach. You may or may not know that with other witnesses, on occasion, I've asked for their perception of the arrangement, the situation, or even the institution of the presidency that would cause them to act or fail to act in a particular way. Can you visualize, in that vein, can you visualize any other person or situation in the whole wide world for which you would have done this other than for a representative of the White House?
Senator, I feel, as I look back on it, that almost certainly Mr. Dean had been asked to talk to me because people knew of the relationship I had with this man and the relationship of trust.
You see, what I'm striving for once again is what is there about the nature of the White House or of the presidency or of the aura that surrounds it?
Yes, sir.
That would cause you to act without question, without concern, as apparently you did, placing great reliance on the propriety of the request because of its origins. Is that?
Total reliance on the trust.
You base that on your reverence for the institution of the presidency or on your personal friendship with him or long acquaintance with either the president or Mr. Dean, or was it a composite of several factors?
I think it was a composite of all of those factors.
Did it ever occur to you to, I know you've testified that you spoke to Mr. Ehrlichman about the matter, to verify Mr. Dean's authority. Did it ever occur to you to speak with the president about it, to find out whether he knew what was going on or did not know what was going on?
No, sir. I felt that in talking to Mr. Ehrlichman, I was talking to someone who would give me the assurance that I required, and I did not think to talk to the president.
Mr. Kalmbach, you've already testified that you have not spoken to the president about Watergate, although I believe you did talk to him the night of the election.
No, sir. It was several days after the election.
I see. Well, sometime shortly after the election.
Yes, sir.
After the events about which you've now testified, and after the continuing publicity and further developments, after the defendants were indicted and, in fact, convicted, after you had a greater source of information and knowledge than you had at the time you first met with Mr. Dean, after you yourself had been, I believe, before the grand jury.
Yes, sir.
Did it ever occur to you to talk to the president about this and find out what the situation was or how this situation might relate to him?
No, Senator. All during this period from the August, September, when I discontinued and withdrew, on through until the time that Mr. Ehrlichman left the White House, I had the feeling always that these men were, Mr. Dean, Mr. Ehrlichman, had the absolute trust of the President, and all I had was this concern. I had no certainty at all, Senator, that there was an impropriety. The level of concern that I had was simply, it bothered me to the point that I would not be involved in it. But I did not know that it was in fact what it is. And all through this period, I just had that level of concern. And here was Mr. Ehrlichman, Mr. Dean continuing at the White House, and I was certain with those people there that my concern probably really was not based on anything at all. But it was sufficient for me, Senator, at that early time to desist.
What about later time? Would you say 3 months later have undertaken the same assignment?
No, sir, I would not have.
What would have changed your mind? What factor, or would it once again be the accumulation or the composite of several factors?
Yes, sir.
Could you describe it for me a little better?
No, sir. I think that my first, when I was approached, within a matter of days after this break-in, by this man, it was just I had no question. The secrecy and all of that, plus the press, plus the other things that came along, raised a level of concern, which was washed out actually when I spoke with Mr. Ehrlichman on the 26th. But shortly after I'd seen Mr. Jones, a fine person who had no knowledge of this at all, but he trusted me and gave me these funds, I was again approached and talked to, and the telephone calls, and just the accumulation of that and the press and other factors was sufficient that I just didn't want to be involved any longer.
Well, now, if you didn't want to be involved any longer at that point, did the thought occur to you that if your concern was that great, that there was some obligation or at least an opportunity to take this matter up with the President and see if he was aware of all these circumstances?
No, sir, it did not. I'd been advised by Mr. Dean and then Mr. Ehrlichman that this was proper and to go forward. And frankly, my concern was based on the secrecy in these procedures, and I felt it would be presumptuous, frankly, with just rumor and just a sixth sense to have gone to the President. Now, I've not met with the President more than 4 or 5 times, other than in social gatherings, over these throughout this period.
Were you still his personal attorney at that time?
Yes, sir.
And did such things as take care of his personal business affairs and transactions? What about the preparation of his income tax return?
Yes, sir, we were involved in all those matters, dealing always through Mr. Ehrlichman or Mr. Dean.
You see, I'm still a little perplexed. Here we have a man who'd known the President for a long time, who was his personal counsel, who accepted a job, in effect, on faith, who became concerned about it, concerned to the point that he sought out a verification of the authority of Mr. Dean to give you this assignment, and later became so concerned that you disengaged from it. Now, surely the body, the substance of your concern at some point must have flickered a warning light that there's trouble here, at least trouble, potentially trouble for you. Did it never flicker the light that there might be trouble for the President in that respect?
It didn't flicker the light, as you put it, that there was trouble in that sense. It bothered me, the secrecy. That was the primary thing. It was distasteful to me, this back and forth to telephone booths, the press, the accumulation, as you put it, Senator, the composite of several factors, but it never reached the point in my mind where I felt that I should go to the President. I had been assured first by this man in whom the President had complete trust, Mr. Ehrlichman, and earlier by Mr. Dean to go forward in this, and I thought, frankly, it'd be presumptuous of me to take it beyond my own decision to desist.
How big would a private... No, I'll not ask that. Mr. Kalmbach, I really don't think I can ask you to help me with the inquiry that I'm trying to make, because it in turn will be answered, if it's ever answered, by the composite of the testimony of several witnesses and my perception of their testimony. What I'd really like to find out is what caused you to act in the way you did, or other witnesses to act in the way they did. You've been fairly explicit in your answers in that respect. But more importantly, I'm trying to find out what there is about the presidency or the White House or the staffing of the White House that would cause, as in the case of the testimony of Mr. Mitchell, if it is accepted at face value, a man, a public servant, a cabinet officer, to make the conscious decision not to tell the president. Or, in your case, to be concerned to the point, for many reasons, that you chose to disengage from this, but never told the president. What is there about it that says, you know, I'm never going to tell this man, or it's not something that I'm going to concern him with? What is there about the nature of the situation that would cause you to act in that way? It is not consonant, for instance, with my conception of a long friendship or an attorney-client relationship. What is there that moderated what I otherwise would expect to be a normal reaction?
There wasn't the relationship, Senator, of easy access, and I had not seen the president in other than in social gatherings since '71.
Maybe easy access is the key to it. Maybe you can't ever have easy access to a modern president of the United States, to a current contemporary president. But are you telling me, in effect, that the question of easy access caused you to act in a way different from the way you would have acted had there been easy access to the president?
No, but again, I think the root of this, Senator, is that I had talked to the man that I knew to be, if not his right arm, and perhaps be Mr. Haldeman, it was at least his left arm, Mr. Ehrlichman. I had expressed myself to this man. This man was in the total confidence of the president. This is a man that I dealt with really through the years in legal work as the president's alter ego. I felt that I'd communicated to Mr. Ehrlichman that, based just on a visceral feel that I had from the nature of the secrecy and all, I felt it was not something that I would go to the president about.
Talk about easy access just for a moment more. The very fact that the situation, as you described it, created, in effect, a little president, created a man who was so important, as you put it, at least the left hand of the president, that you could verify the authority of another person to act, and that would obliterate from your mind any concern for the propriety of these actions. Does the creation of that staff relationship have some bearing on your isolation or your lack of access to the president, to the extent that you might have acted a different way if John Ehrlichman had not been there and vested with that authority?
Yes,
Would
sir.
these visceral feelings have led you then, if you had easy access by phone or by personal contact, would these visceral feelings have led you to go to the president and say, something's going on and I don't like it and I'm getting out and I suggest you look into it? Might that then have happened?
Yes, sir.
Thank you, Mr. Chairman.
You have stated you got $75,000, I believe, mostly in $100 bills from Morris Stans, and a contribution of $75,000 in a wrapped-up package of money from Mr. Jones of the Northrop Company. That makes $150,000. Where did you get the other $70,000?
From Mr. LaRue, Senator.
So, with the $75,000 you got from Morris Stans, the $70,000 from Fred LaRue, and the $75,000 you got from Mr. Jones, you managed to distribute in a surreptitious manner to the families and counsel of the people indicted in the Watergate affair, sums totaling $220,000.
Substantially that.
And you did this at the instance of John Dean and Fred LaRue, and with the approval of John Ehrlichman.
Yes, sir.
Yes. Well, didn't John Dean and Fred LaRue and John Ehrlichman live in Washington, whereas you lived in California?
Yes, sir.
Didn't you know that was anything to prevent them from delivering the money to the lawyers or their families or to Mrs. Hunt here in Washington?
I'm sorry, Senator.
Was anything whatever to prevent John Dean or Fred LaRue or any of their other associates here from delivering this money to the lawyers and the defendants and Mrs. Hunt in Washington?
No.
Well, didn't it occur to you at all times, and didn't you know at all times, that the reason that you were asked, a resident of California, to arrange for the distribution of this money through the agency of Ulasewicz was to conceal from the American people what was happening?
Mr. Chairman, my understanding was that I was being given an assignment that was very confidential and was asked to carry it forward.
Well, to go back to my question, didn't you know at all times that this arrangement was made by John Dean and Fred LaRue with the approval of John Ehrlichman to have you deliver this money in a surreptitious manner through Ulasewicz, a resident of New York, to hide from the American people what was happening?
No, sir, I did not understand that. I understood that I was being given an assignment, very confidential in nature, to effect the payment of these funds.
Well, didn't you understand that you were being given an assignment which was so confidential in nature, it was going to be hid from everybody except those concerned?
Mr. Chairman, I was again just understood that it was to be absolutely confidential, and for the purpose and for the reasons that I've stated.
Well, doesn't absolute confidentiality imply absolute secrecy?
Yes, sir.
And doesn't absolute secrecy imply hiding things from the world in general?
Well, in this, Mr. Chairman, in the election year that was the case in mid-year 1972, I was advised that the reason for the confidentiality, absolute secrecy, was for that purpose and to avoid misinterpretation.
Well, aren't the people entitled to know more in an election year when they have to choose a president than any other time?
They are entitled to know, yes, sir.
Well, it's inescapable to me that this arrangement was set up in order to conceal what was the distribution of this money and the identity of the parties who were distributing it and the identity of the parties who were receiving it. Isn't that inescapable conclusion from your testimony?
From my testimony, Mr. Chairman, it is true that the reason I was asked to do this was to raise these funds for these individuals and for attorneys, and the reason for the confidentiality requirements was expressed to me as I've testified.
Well, I think we've come to the same conclusion, but in different phraseology. Now, do you have any reason to conceal your relationship to John Ehrlichman?
Sir?
Do you have any reason to conceal your relationship to John Ehrlichman?
No, sir.
Didn't you loan him $20,000?
Yes, sir, I did.
And instead of giving him a check for $20,000, you gave your check to the Security Pacific National Bank on May the 5th, 1972 for $20,000, and with this proceeds purchased a cashier's check from the Security National Bank dated the same day to John Ehrlichman for $20,000.
That is correct.
Why did you do that?
Again, Mr. Ehrlichman asked me for confidentiality. It was a personal loan and between friends, and I gave him the cashier's check for that purpose from my own funds, Mr. Chairman.
Well, I understand, but you also on one occasion, June the 30th, 1970, loaned $20,000 to Mr. Robert H. Finch, didn't you?
On what date?
On June the 30th, 1970.
That is correct.
But you gave, instead of getting the cashier's check in that case, why you gave him your personal check, did you not?
Yes, sir, I did, but he had not asked that I treat it as confidential.
Now, did you take a note from Mr. Ehrlichman when you loaned him the $20,000?
Yes, sir, I did.
Now, you stated that there was nothing wrong or nothing at least illegal in your destruction of the records of the monies that you held in your capacity as trustee from the, which had been derived from contributions to the 1968 election.
Mr. Chairman, I have testified that I gave over to the Finance Committee what I considered to be the base or original records for all of my activities, which included an accounting for what I dispersed from the boxes from the time that the trusteeship arose.
Well, as the trustee of these funds, didn't you occupy a fiduciary relationship?
I certainly did.
And doesn't the law require that one who occupies a fiduciary relationship maintain and keep records of his transactions in that capacity?
I think that it is true, Mr. Chairman, that a fiduciary must maintain accurate records, which I did. I met with Mr. Stans, reviewed with him, and gave him a 7 or 8 page accounting for funds that had been dispersed through this period. I gave him base or original records of everything that had gone on. There was, except for the inadvertent destruction of some checks, all of these records that were given to Mr. Stans were original. And again, except for that inadvertency, all the records that I retained, which were, in my view, personal and supportive of the records I'd given to Mr. Stans, I felt that I wanted to destroy, again for the purpose, Mr. Chairman, that I wanted to protect the confidentiality of my relationship with the people that I'd talked to.
So you destroyed the records, your records which supported the records that you gave to Mr. Stans?
I destroyed, again, with that one exception.
And you did that to make it impossible for anybody to ever discover who had made the contributions which you collected?
No, sir. The records that I gave to Mr. Stans accurately reflect the people that I saw and the amounts and funds that I had received.
Well, if you destroyed your own the records you retained after giving those records to Mr. Stans, you did it for the purpose of making it impossible to determine from the records you retained the contributions you'd received, the identity of the people who made those contributions, didn't you?
Mr. Chairman, what I did was to destroy supportive records, not original records, personal and supportive records, again for the reason to protect the confidentiality.
Isn't the only thing that you gave to Mr. Stans was an accounting of the money you had on hand as you turned over to Mr. Stans?
No, sir. There was several pages involved in that accounting, tracing the funds that I had originally started with through the various boxes and disbursements.
But didn't you destroy all your bank records and all of the checks that you had issued?
The bank records themselves were destroyed, but the disbursements were reflected, Mr. Chairman, in this accounting.
But the disbursements didn't show to whom they were disbursed, did they?
I don't recall in that accounting, Mr. Chairman.
So all it showed was that you turned over, Mr. Stans showed was the amounts.
No, sir. I showed there was a very detailed accounting. Mr. Stans, Mr. Chairman, retrieved 2 or 3 pages of that accounting, and it was very specific.
Now, didn't you suspect that when you raised this money and distributed in this surreptitious manner to the lawyers and families of the parties that had been indicted in the Watergate, that you were aiding the Nixon campaign for re-election?
I was carrying out an assignment, Mr. Chairman.
Well, didn't you suspect that you were asked to do this because it would aid the campaign of the president for re-election?
No, sir. I was doing this for the purpose that I stated, that it was an assignment. I thought a moral obligation had in some manner been created, and I was raising funds for the purposes stated.
You didn't have the remotest idea that you were doing anything to assist the re-election of the president?
No, sir.
And you didn't even you didn't even have any idea of that kind in your mind when you applied to Mr. Jones for a contribution for the president's campaign fund?
No, sir.
Well, you left the impression on Mr. Jones's, in Mr. Jones's mind, that you were raising money for the re-election of the president, didn't you?
I told Mr. Jones that I was raising funds for a special assignment, and I did not go beyond that.
You didn't
Chairman.
tell him whether it's a special assignment to create a foundation for the feeding of transatlantic whales or something?
No, sir.
Well, had you raised campaign funds for Mr. Jones before?
Funds had been raised for Mr. Jones prior to that time.
Well, didn't you believe at the time Mr. Jones gave you the $75,000 in this package of money that he believed you were raising campaign funds for the president's campaign?
I think that would have been a logical feeling.
But you weren't doing that. You were raising money to pay the lawyer fees of the lawyers who were defending the people indicted in the Watergate matter and supporting their families while the trials were pending, weren't you?
And I was doing that, Mr. Chairman, in the belief that it was absolutely proper.
Yes. But do you believe Mr. Jones would have given you $75,000 if you had told him that you were going to give it to aid in the defense of some burglars who had broken into the Democratic headquarters in Washington?
Well, Mr. Chairman, I don't know. If I had told Mr. Jones that, in my view, that this was for the purpose, I think he may well have given those funds for a very proper purpose where there was a moral obligation involved.
Yes. Now, as a matter of fact, however, you concede, as I understand it, that you left Mr. Jones under the impression that you were raising these funds for campaign purposes.
Yes, sir.
Yeah. Now, can you tell me why you thought or suspected that men like John Dean and Fred LaRue and John Ehrlichman were interested in raising funds to give to the attorneys? Now, didn't you suspect that when you raised this money and distributed in this surreptitious manner to the lawyers and families of the parties that had been indicted in the Watergate, that you were aiding the Nixon campaign for re-election?
I was carrying out an assignment, Mr. Chairman.
Well, didn't you suspect that you were asked to do this because it would aid the campaign of the president for re-election?
No, sir. I was doing this for the purpose that I stated, that it was an assignment. I thought a moral obligation had in some manner been created, and I was raising funds for the purposes stated.
You didn't have the remotest idea that you were doing anything to assist the re-election of the president?
No, sir.
And you didn't even suspect, you didn't even have any idea of that kind in your mind when you applied to Mr. Jones for a contribution for the president's campaign fund?
No, sir.
Well, you left the impression on Mr. Jones's, in Mr. Jones's mind that you were raising money for the re-election of the president, didn't you?
I told Mr. Jones that I was raising funds for a special assignment, and I did not go beyond that.
You
Mr.
didn't
Chairman.
tell him whether there's a special assignment to create a foundation for the feeding of transatlantic whales or something?
No, sir.
Well, had you raised campaign funds for Mr. Jones before?
Funds had been raised for Mr. Jones prior to that time.
Well, didn't you believe at the time Mr. Jones gave you the $75,000 in this packet of money that he believed you were raising campaign funds for the president's campaign?
I think that would have been a logical feeling.
But you weren't doing that. You were raising money to pay the lawyer fees of the lawyers who were defending the people indicted in the Watergate matter and supporting their families while the trials were pending, weren't you?
And I was doing that, Mr. Chairman, in the belief that it was absolutely proper.
Yes. But do you believe Mr. Jones would have given you $75,000 if you had told him that you were going to give it to aid in the defense of some burglars who had broken into the Democratic headquarters in Washington?
Well, Mr. Chairman, I don't know. If I had told Mr. Jones that, in my view, that this is for the purpose, I think he may well have given those funds for the very proper purpose where there was a moral obligation involved.
Yes. Now, as a matter of fact, however, you concede, as I understand it, that you left Mr. Jones under the impression that you were raising these funds for campaign purposes.
Yes, sir.
Yeah. Now, can you tell me why you thought or suspected that men like John Dean and Fred LaRue and John Ehrlichman were interested in raising funds to give to the attorneys and for 5 burglars who were caught red-handed in the Watergate and 2 accessories before and after the fact of that burglary?
Again, Mr. Chairman, I think it was simply that they felt and so advised me that this was a proper thing for me to do, proper assignment for me to carry out, and for the reasons that I've stated.
And didn't you have enough curiosity to ask anybody as to why it was a proper assignment for you to handle money in such a repetitious fashion for the benefit of some burglars and their accomplices?
Mr. Chairman, when I spoke to Mr. Ehrlichman on the 26th, I made it plain, very plain to him that these secrecy procedures were bothersome to me. And I asked that he confirm John Dean's authority, confirm the propriety, and to go and ask him that I should go forward.
Now, as I deduced from the testimony you gave on the examination of Senator Talmadge,
yes, sir,
you suspected that there was some connection between somebody either in the White House or somebody involved in the committee to re-elect the president and the burglary of the Watergate.
Yes, sir.
Yeah.
I think again that Mr. Dean, whether he was speaking, and I don't know who he was speaking for when he came to me, and I still don't. But I felt that he had ties, and I knew that he had ties with the committee to re-elect and, of course, ties within the White House.
And when you talked to John Ehrlichman about this, John Ehrlichman told you that it was an important assignment, that you should carry it out, and if this money was not raised, that they will have our heads in their laps.
No, sir. He did say it was an important assignment, that John Dean did have the authority, and that I should go forward. The statement that Mr. Ehrlichman made about heads in the laps was meant that if this is the reason for the secrecy procedures, that if in fact I didn't follow these secrecy procedures and it got into the press, it could be misinterpreted and would jeopardize the campaign.
Well, he did tell you that if this submission was not kept secret, this assignment was not kept secret, that they would have our heads in their laps. And you took that to mean that they were some Democrats.
Yes, sir.
All the public press.
Yes, sir.
Yeah. Now, you knew at that time, did you not, that it had appeared in the public press all over the nation and on TV that 5 burglars had been caught red-handed in the Watergate, and that at that time they had in their pockets monies which had come from the Nixon campaign fund, didn't you?
Yes, sir. I think I believe that.
That was one of the things that excited in your mind the suspicion that there might be some connection between somebody in the White House or in the campaign in the committee to re-elect the president, that they had procured the burglary of the Watergate, didn't they?
I think it entered into my mind, Mr. Chairman, that was certainly a factor which indicated that they'd been given the go-ahead by someone at the committee to re-elect.
Now, didn't you have a phone conversation with John Ehrlichman on April the 19th, 1973 at 4:50 p.m., just before the day before you were scheduled to go before the grand jury?
Yes, sir, I did.
And didn't John Ehrlichman suggest to you that you should emphasize that he and Bob Haldeman had nothing to do with any of these matters?
I don't recall that was what was stated, but I do recall the conversation. I think that he indicated that in that conversation that Mr. Dean had talked to both he and Mr. Haldeman. Yes, sir, I remember that.
Yes, well, he told you, that is, John Ehrlichman told you in that conversation that Dean had gone to the prosecuting attorney and was seeking immunity, and that he, Dean, was throwing off on Bob Haldeman and John Ehrlichman, didn't he?
I think that's substantially what I remember.
And didn't he suggest that you testify as far as you could so as to implicate Dean and exonerate Haldeman and Ehrlichman?
I did not so understand it, Mr. Chairman. I understood him to say to tell the complete truth.
Well, let's see. Didn't he tell you that you ought to I told you among other things, didn't he? He said this: I wouldn't haul the president into it if I can help it. Didn't Ehrlichman ask you that?
Excuse me, Senator. May I read this, please?
Page 4, top of page 4.
Mr. Chairman, in fairness, wouldn't it be proper to give the witness a few minutes to read the entire document that's been presented to him? Apparently, it's the first time he's seen it.
It is. Thank you very much.
Mr. Chairman, I'd like to also say that it's my understanding, I may have missed it in your inquiry, that what you're reading from is a question and answer telephone conversation transcript, which is apparently recorded and supplied to us by Mr. Ehrlichman in the course of his interview, and also, in fairness, as Senator Weicker said, to the record. I wonder if we might have the entire document included in the record so that it would be available for ready reference.
Consistent with the fact that as of March 15, when Mr. Kalmbach and I first declared that we would cooperate with this committee and have done so up to this time, I believe it was upon our advice that Mr. Dash and Mr. Lenzner became aware of this very tape. We have not, however, as yet read it, and we would appreciate that opportunity.
Well, I was under the impression, and I'm sorry if my impression was wrong, that Mr. Kalmbach had a copy of this. And certainly I don't want to be unfair to anybody, and I certainly would accord him an opportunity to read it.
Mr. Chairman, I wonder if there is any objection on behalf of the committee or the witness to including this as an exhibit to the record.
I have none.
And I ask unanimous consent that it be included in the record at this point as an exhibit appropriately numbered.
That will be done and numbered appropriately as an exhibit and included in the record as such.
As Mr. Kalmbach looks over his transcript of the April 19th telephone conversation, we're going to interrupt our playback. Public television's coverage of the Senate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
We pick up the hearings with Senator Ervin asking about a recording of a telephone conversation between John Ehrlichman and Herbert Kalmbach. But before we go back to the caucus room, we'd like to read you a longer portion of that conversation because it's not read in full during the hearing. About a third of the way through the conversation, Kalmbach refers to the meeting he had in June of 1972 when he saw Ehrlichman to get confirmation that his money-raising for the Watergate 7 was proper. And the transcript takes up, Kalmbach, you know that when you and I talked, and it was after John Dean had given me the word, and I came in to ask you, John, is this an assignment I have to take on? You said, yes, it is, period, and move forward. Then that was all I needed to be assured that I wasn't putting my family in jeopardy. Ehrlichman, sure. Kalmbach, and I would just understand that you and I are absolutely together on that. Ehrlichman, no question about it, Herb, that I would never knowingly have put you in any kind of a spot. Kalmbach, yeah. Well, and when we talked, you knew what I was about to do. You know, to go out and get the dough for this purpose. It was humanitarian. Ehrlichman, it was a defense fund. Kalmbach, to support the family. Now, the thing that was disquieting about this thing with O'Brien was that he said there's a massive campaign evidently underway to indict all the lawyers, including you, Herb, and I was a little shocked. And I guess what I need to get from you, John, is assurance that this is not true. Ehrlichman, well, I don't know of any attempt to target you at all. My hunch is that they're trying to get at me. They're trying to corroborate. See, what they said to Dean is that he gets no consideration from them unless they can corroborate Haldeman and my liability. Kalmbach says, God, if I can just make it plain that it was humanitarian and nothing else. Ehrlichman, yeah, and the point that I undoubtedly never expressed to you, that I continually operated on the basis of Dean's representations to me. Kalmbach, yep, it was not improper. Ehrlichman says, right. Kalmbach, and there was nothing illegal about it. Ehrlichman, see, he's the House lawyer. Kalmbach, yep, exactly. And I just couldn't believe that you and Bob and the President, just two good friends, to ever put me in the position where I'm putting my family on the line. And it's just unbelievable, unthinkable. Now, I'll just, if I'm asked by Silver, I'll just lay it out exactly that way. Ehrlichman, yeah, I wouldn't haul the President into it if you can help it. Kalmbach, oh no, I will not. Ehrlichman, but I think the point, which I will make in the future if I'm given the chance, that you were not under our control in any sort of a slavery sense, but that we'd agreed that you would not be at the beck and call of the committee. Kalmbach, and of course, too, that I act only on orders, and you know on direction, and if this is something that you felt sufficiently important, and that you were assured it was altogether proper, then I would take it on because I always do it and always have, and you and Bob and the President know that. Ehrlichman, yeah, well, as far as propriety is concerned, I think we're both relying entirely on Dean. Kalmbach, yep. Ehrlichman, I made no independent judgment. Kalmbach, yeah. Ehrlichman, and I'm sure Bob didn't either. Kalmbach, nope. And I have the feeling, John, that I don't know if this is a weak read. Is it? Ehrlichman, who, Dean? Kalmbach, no, I mean, are they still going to say, well, Herb, you should have known? Ehrlichman, I don't know how you could. You didn't make any inquiries. Kalmbach, never. And the only inquiries I made, John, was to you after I talked to John Dean. Ehrlichman, and you found out that I didn't know just a whole hell of a lot. Kalmbach, you said this is something I have to do, and Ehrlichman, yeah, and the reason I said that, as you know, was not from any personal inquiry, but was on the basis of what had been represented to me. Kalmbach, yeah, and then on to provide the defense fund and to take care of the families of these fellows who were then, Ehrlichman says, indigent. Kalmbach, not then been found guilty or not guilty. Ehrlichman, and the point being here, without attempting to induce them to do a damn thing. Kalmbach, absolutely not. And that was never. That was exactly right. Ehrlichman, okay. Kalmbach, now, can I get in to see you tomorrow before I go in there at 2? Ehrlichman, if you want to, they'll ask you. Kalmbach, will they? Ehrlichman, yep. Kalmbach, well, maybe I shouldn't. Ehrlichman, they'll ask you to whom you've spoken about your testimony. And I'd appreciate it if you would say you've talked to me in California, because at that time I was investigating this thing for the President. Kalmbach, and not now? Ehrlichman, Well, I wouldn't ask you to lie. Kalmbach, no, I know. Ehrlichman, but the point is. Kalmbach, but the testimony was in California. Ehrlichman, the point is. Well, no, your recollection of the facts and so forth. Kalmbach, yes, I agree. Ehrlichman goes on, see, I don't think we were ever seen together out there, but at some point I'm going to have to say that I talked to O'Brien and Dean and Magruder and Mitchell and you and a whole lot of people about this case. Kalmbach, yeah. Ehrlichman, and so it would be consistent. Kalmbach, do you feel, John, that calling it straight shot here, do you feel assured as you did when we were out there that there's no culpability here? Ehrlichman, yes. Kalmbach, and nothing to worry about? Ehrlichman, and Herb, from everything I hear, they're not after you. Kalmbach, yes, sir. Ehrlichman, from everything I hear. Kalmbach, Barbara, you know. Ehrlichman interrupts, they're out to get me and they're out to get Bob. Kalmbach, my God. All right. Well, John, it'll be absolutely clear that there was nothing looking towards any cover-up or anything. It was strictly for the humanitarian. And I just want, when I talked to you, I just wanted you to advise me that it was all right on that basis. Ehrlichman, on that basis. Kalmbach, to go forward. Ehrlichman, that it was necessary. Kalmbach, and that'll be precisely the way it is. Ehrlichman says, yeah, okay, thanks, Herb, bye. Well, that's the end of the transcript of the hearings, which was read, of the conversation which was read at the hearings. Now back to the hearings themselves as the committee continues questioning Kalmbach about this conversation.
Yes, sir.
Now, didn't in this telephone conversation, which was taped by John Ehrlichman, isn't it recorded that John Ehrlichman told you, and I refer to page 3, that they, that is the prosecuting attorneys, were trying to get at him, that is John Ehrlichman, and that they would give Dean no consideration unless they can corroborate Haldeman and my liability. In other words, didn't he tell you in substance that the prosecuting attorneys were trying to get at him, John Ehrlichman?
He indicated here, and incidentally, Mr. Chairman, I can't tell you or the members of this committee my reaction at the time that I learned that I'd been taped. Without my knowledge or consent, I just cannot express the feelings at that time. But well, I'm sure you understand.
Didn't he state that to you at that time?
He stated per the testimony, yes, sir.
Yes. And he stated that there was no chance for Dean to get immunity unless Dean could substantiate some liability in the matter on the part of Haldeman and Ehrlichman.
Again, per this testimony, Mr. Chairman.
Now, I'll call your attention to the statement made by Ehrlichman at the bottom of page 2. And so it was necessary for Dean to come to me, that is Ehrlichman, and then in turn to Bob, and plead a very urgent case without really getting into any specifics, except to say you had to trust me. This is very important. And Mitchell is up his tree. All you know, I mean, is really worked up. He didn't use that phrase, but is really exercised about this. And I said, well, John, if you tell me it's that important, why, yes. Now, didn't that mean that Ehrlichman wasn't Ehrlichman thereby saying that John Dean had come to him and Bob Haldeman with this plan to use this money to pay money to the defendants and their families, and that he said to Dean that if that's important, why, yes, for him to go ahead with the project.
That is the way I would read this.
Yes. And then you said, back to John Ehrlichman, you know, when you and I talked, and it was after John had given me that word, and I came in to ask you, John, is this an assignment I have to take on? You said, yes, it is, period, and move forward. Then that was all that I needed to be assured that I wasn't putting my family in jeopardy. And Ehrlichman said, agreed, said sure.
That is correct.
And then you said, and I would just understand that you and I are absolutely together on that, meaning you both agreed on that point.
That is what he had told me in the office, yes, sir.
Now, then this conversation indicates an agreement on your part to testify that the use of this money was for humanitarian purposes.
No, sir.
Well, let's see, what does this mean? Ehrlichman said, well, I don't know of any attempt to target you at all. My hunch is that they're trying to get at me. They're trying to corroborate. See, what they said to Dean is he gets no consideration from them unless they can corroborate Haldeman and my liability. And you stated, God, if I can just make it plain that it was humanitarian and nothing else.
And that is exactly what I understood at the time.
Well, either the White House or the committee to re-elect the president this time an eleemosynary institution?
No, sir. But I believe, Mr. Chairman, as I've stated, that at that time that I felt that these people had been ordered to go forward on this project and by someone in responsibility, probably at the committee to re-elect, and that I had been asked by these people through Mr. Dean to do this. And I understood it to be humanitarian, and I understood it to be for that purpose, and certainly not for any illegal purpose.
Well,
I would never have ever agreed to undertake any illegal act.
Well, didn't Mr. Ehrlichman's conversation to you, when you went to check on whether Dean had authority, suggest to your mind that Mr. Ehrlichman was afraid it would not be kept secret unless this money was raised and these people paid?
I'm sorry, Mr. Chairman, but
didn't Mr. Ehrlichman's conversation with you about this mission and about John Dean's authority to ask you to perform this assignment, and his statement about the necessity of secrecy, engender in your mind a conviction that Ehrlichman thought that if this money was not raised, that these people might disclose what the connection was between the Watergate burglary and them and some other people?
No, sir. My testimony is, and that my belief at that time was that the reason that he asked me to undertake this and the reason that he asked me to follow the secrecy procedures that were followed was to make certain that this did not get into the press, be misinterpreted, and jeopardize the campaign.
But you embarked upon this and engaged in it because you stated because you felt like there was some connection between somebody in authority, either in the White House or in the committee to re-elect the president, and the Watergate burglary.
Yes, sir.
Then it never, and you said that one reason about keeping the secrecy was so that the payment of the money would not be misinterpreted.
That is correct.
Well, did you not fail? And did not John Ehrlichman's language to you suggest that he feared that if these people were not paid this money, that they might speak up and reveal what the connection was between them and some person in authority?
No, sir. My belief was that, again, that the reason for this secrecy was to prevent it from getting into the press, being misinterpreted, and jeopardizing the campaign.
Well,
I had no question, Mr. Chairman, on the propriety of doing this for these people.
Well,
I thought, again, it was a human thing to do. A very human thing.
You ever known of a political party to engage in humanitarian acts like this before or since?
Well, again, Mr. Chairman, I believe that it was proper.
Well, what was a misinterpretation you feared might be placed upon this payment of this money to the defendants and their families if it became known to the press?
At the time the misinterpretation comment was made, that was all that was stated, that it would be misinterpreted in the press in whatever manner that would jeopardize the campaign.
Well, can you conceive of any interpretation that was likely to be put upon it in the press except the interpretation that this was money to cover up the connection between the person in authority that you suspected but do not know or identify and the Watergate burglary?
Mr. Chairman, again, in retrospect, certainly that was the misinterpretation that was feared. But at the time that I was asked to do this, it didn't even cross my mind.
It never even, although you suspected that somebody in authority, either in the White House or in the committee to re-elect the president, had procured the burglarizing of the Watergate, it never occurred to you that the fact that money was paid to the people who did burglarize the Watergate would raise a suspicion that they were paid to keep silent?
It did not. I would not have undertaken any assignment for an illegal act. I would not.
Can you imagine any interpretation that would have been placed on the matter other than that?
I have testified as to my state of mind at that time, and my state of mind was prompted by being asked by Mr. Dean and then Mr. Ehrlichman.
Now, Mr. Ehrlichman was John Dean's superior, wasn't he, in authority in the White House?
Yes, sir.
Yeah. And yet, in this phone conversation, Mr. Dean suggests to you on page, Mr. Ehrlichman, on page 4, well, as far as propriety is concerned, I think we both were relying entirely on Dean. And you say, yep.
Mr. Dean told me that it was proper. And then when I talked to Mr. Ehrlichman on the 26th, he reaffirmed that.
And Ehrlichman said, I made no independent judgment. That is, Ehrlichman made no independent judgment about the matter. And you say, yep, yep.
He told me that when I talked to him on the 26th that it was proper and to go forward.
Well, I was asking you what you said, not on the 26th, but I was asking what you said to him in this taped phone conversation. Page 4.
Yes, I see that.
Well, you stated you didn't think, you thought at the time that Ehrlichman told you the project was, that the assignment was right and could be carried out, you thought he'd made an independent judgment about the matter and was not relying entirely on Dean, didn't you?
He didn't indicate, Mr. Chairman. He indicated simply to go forward.
Well, how could you testify that, how could you give your affirmative assent to the fact that John Ehrlichman had made no independent judgment about this matter at all?
I'm sorry, I didn't understand your question.
Well, John Ehrlichman is talking to you evidently about the fact you were going before the grand jury, and he said, as far as propriety is concerned, I think we both were relying upon Dean, you and he, as to the wisdom of the propriety of this assignment.
I did not know what was the background for his judgment and direction to me on the 26th of July, 1972.
Yeah, I'm asking you about what you said in this tape conversation on April 19th, 1973. And you agreed by using the word yep in response to his statement that as to the propriety of this transaction, that is, the proprietor surreptitiously paying this money to the Watergate defendants and their lawyers, that you and Ehrlichman both relied upon Dean alone?
I've indicated to you, Mr. Chairman, that I relied completely on Mr. Dean and Mr. Ehrlichman. Now, Mr. Ehrlichman in this statement says that he relied on Mr. Dean. I did not know, and as far as my answer in the affirmative, yes. Well, if that's what he relied on, well, whatever it was.
Well, that's the reason I couldn't understand why you gave your assent to the proposition that Ehrlichman, relied solely upon Dean.
Mr. Chairman, again, I did not know the background for Mr. Ehrlichman's assurance to me at the time.
Well, you knew that you didn't rely solely upon Dean because Dean had already given you the assurance about it, and you were not satisfied with his assurance, and you went to John Ehrlichman to get assurance from him, didn't you?
Mr. Chairman, I went to Mr. Ehrlichman almost a month later after I began to receive a degree of concern, and that's when I went to see Mr. Ehrlichman.
Well, that's the reason I'm asking you this question. If you yourself did not rely, after you'd given money to Dean on several occasions, or rather had given money furnished money to be conveyed in this surreptitious fashion to these defendants and their lawyers, you had doubts about Dean's authority and about the propriety of the act, and you went to Ehrlichman to get reassurance on that, didn't you?
Yes, sir, I did.
And so you relied thereafter upon Ehrlichman because you had ceased to rely on Dean.
Yes, sir, I had it confirmed by Mr. Ehrlichman.
Then after John Ehrlichman suggested to you in this telephone interview that he had no independent judgment, and he said, and I'm sure Bob, that is referring to Bob Haldeman, I imagine, didn't either. He had no independent judgment about the matter. And you say no.
Again, Mr. Chairman, what page are you on?
That's on page 4, near the bottom of the page.
Again, Mr. Chairman, I did not have any knowledge as to whether at the time whether Mr. Ehrlichman was relying on Mr. Dean or on whatever. He simply made it a flat statement, categorical statement, that it was proper, that Mr. Dean had the authority, and that I should go forward.
But in this conversation, you stated that Haldeman was telling you Ehrlichman, telling you a prospective witness before the grand jury the next day, which was investigating Ehrlichman's conduct, that both you and Ehrlichman relied solely upon Dean's judgment as to the propriety of this transaction. And you agreed with him.
Mr. Chairman, in this comment, I indicated to him, yep, and asked him to go forward in our conversation. Now, I did not understand at the time that he had whether he had independent judgment or not.
But this is a conversation which occurred many months. In other words, you ceased to operate in this field, you said, in September.
August
and September. This is a conversation which you had with Ehrlichman in the following April of the next year. So you couldn't have been talking about the original the going forward with the distribution of money.
Mr. Chairman, if I may,
yes.
As I reminded the chairman, perhaps the chairman was not aware, this document that the chairman is using was furnished through us to Mr. Dash and Mr. Lenzner. We had not until this time had an opportunity to read it. I'm just looking at your opening statement again, Mr. Chairman, that the purpose of these hearings is not prosecutorial or judicial.
It is not. It is not.
But investigating.
Yes.
And I think in fairness there, Mr. Chairman, it would be proper to ask the witness the occasion for this phone call between himself and John Ehrlichman, which took place in April of this year, just several months ago. In the light of that, or the context of the setting of that phone conversation, Mr. Chairman, I believe some of the questions and answers that are coming out now would be fair in an investigative manner, sir.
Mr. O'Connor, this committee is engaged, among other things, in an effort to determine whether there was an organized effort among any group of people to cover up the truth in respect to the Watergate affair. And it's trying to find out particularly whether or not the money was paid to these people to get them to plead guilty and to keep silent. And I think these questions are very relevant along that point. And the fact that Mr. Ehrlichman, this is not, I don't consider derogatory fundamentally to Mr. Kalmbach, but one of the persons we're investigating is Mr. Ehrlichman. And here is Mr. Ehrlichman, according to the way I interpret this, and if I'm wrong, Mr. Kalmbach can correct me. Mr. Ehrlichman is talking to Mr. Kalmbach the afternoon of the day before he knows Mr. Kalmbach is going before the grand jury to testify about these matters. And he is suggesting to Mr. Kalmbach that, as I construe it, expressing at least, indicating at least an unexpressed hope, which seems to have been very real, that Mr. Kalmbach would testify that Mr. Ehrlichman had no independent judgment about this matter, and they was relying solely upon John Dean as to the ethics and propriety of this payment of money. And Mr. Kalmbach, if he can testify on that, that's the way I construe it, and if my construction is wrong, that is Mr. Ehrlichman's proposal, not Mr. Kalmbach's proposal. And as I construe this, right after the discussion of this, that Mr. Kalmbach says in the line, right after this, after Ehrlichman had suggested that Bob Haldeman didn't know, relied on Dean too, that Mr. Ehrlichman said, Mr. Kalmbach said, John, I don't know if this is a weak read. Is it? And I think that Mr. Kalmbach was asking Mr. Ehrlichman if the idea Mr. Ehrlichman was trying to get him to express in his testimony was not a very weak read for anybody to lean on. Now, I just don't believe, I think he can answer that. Did you express the opinion? Did you intend to express the opinion to Mr. Ehrlichman that the notion that Mr. Ehrlichman was trying to get over, that neither he nor Bob Haldeman exercised any independent judgment about the ethics or propriety of this payment of money, was a weak kind of a read to try to lean on before the grand jury?
Mr. Chairman, at this conversation, I had no knowledge that Mr. Ehrlichman back in July of 26 was relying on anything other than he just made a flat statement to me to go forward.
Well,
and that is what I've testified to, Mr. Chairman.
Well, I'm not asking you about that. I'm asking you about the conversation you had with John Ehrlichman by telephone in April the 19th of 1973. And if you didn't, in effect, tell John Ehrlichman that conversation, that the notion that they could lay the responsibility, sole responsibility for persuading him, that is Ehrlichman, and Haldeman, that this was there was propriety in this use of money was a weak read to lead on.
May I read this again,
Yes.
please? Mr. Chairman, I just don't know how to answer your question. I don't know how to read this other than, again, to repeat what I've stated several times to you and to the other members of this committee, that I relied on Mr. Dean and then Mr. Ehrlichman, and as far as I knew at that time when I spoke to Mr. Ehrlichman, he was telling me his own judgment.
Well, are you unable to testify that you expressed an opinion to John Ehrlichman on the 19th day of April 1973 that any attempt on his part that to establish a proposition that he and Bob Haldeman had believed that this was entirely proper because John Dean told them was not a weak reed to lean on in the court before the grand jury? That's exactly what I think you say. I'm not trying to impeach you. I'm trying to commend what may turn out to be wisdom on your part in observing that this proposition that John Dean, who seems to have been something in the nature of a messenger boy around the White House and subject to Haldeman and Ehrlichman, was the man responsible for leading them astray and responsible for Ehrlichman sanctioning this assignment that you performed.
It seems to say that, Mr. Chairman, but I just don't, I'm not certain, but it does seem to say that.
Well, that's the only thing I've been trying to find out.
Mr. Chairman, either now or at the conclusion of your questioning, I'd like to go into this point. I started out thinking I had this point clearly in mind, and now I think I'm thoroughly confused. So I'll do it at this point, or I'll do it when you finish, but I do want to reserve the right to discuss
now,
that.
I'll invite your attention to page 5. The committee will recess and go and vote and come back. And in the meantime, I'm going to ask you about your testimony on the bottom of page, near the bottom of page 5, about when you had a conversation with him. What John Ehrlichman wanted you to say about the place of a conversation with you.
The transcript of that fascinating telephone conversation has whetted the committee's appetite for more of Mr. Kalmbach. And after returning from a roll call vote, there will be still another round of questions for Mr. Kalmbach.
I have some difficulty interpreting the part of the last part. It's clear enough at starting with your statement now. Can I get in to see you tomorrow before I go in there at 2 o'clock? I presume that was referring to the time you were scheduled to go before the grand jury.
Yes. Mr. Chairman, as I've reviewed this and remembering, Mr. Chairman, that this conversation was taped without my knowledge, without my consent, I must feel that this is self-serving.
Well, Mr. Kalmbach, Kalmbach, I'm sorry that you misconstrued my examination.
Yes, sir, I did.
I did because I'm just a country lawyer from way down in North Carolina, and I I'll probably make inquiries with a little bit more vigor than some of these highfalutin city lawyers do. But what I was trying to ascertain whether or not I could infer from the statements that this tape recording indicates that John Ehrlichman made in this conversation represented an effort on his part to advance the theory that John Dean should be made a scapegoat and sent out into some wilderness, legal wilderness, bearing the full responsibility for any impropriety or unethical aspects of this use of the money. I wasn't seeking it to asking you these questions to impeach you about in connection with the conversation, because my information is that you have corroborated, you have cooperated fully with the prosecution and also fully with this committee.
Yes, sir.
Now, I want to ask you about this. If the last part of this, where it says that maybe you shouldn't see Ehrlichman the next day before you went before the grand jury, what follows that? Ehrlichman says this: they'll ask you to whom you have spoken about your testimony, and I would appreciate it if you would say you've talked to me in California, because at that time I was investigating this thing for the president. You know exactly what and then you put the answer, and not now, in the form of a question back to him.
Yes,
now,
sir.
What did you understand him to be saying to you by that statement?
I think that my understanding, Mr. Chairman, is that when I was when Mr. Ehrlichman was in California, I had several things I needed to talk to him about. I met with him on, I think it was the 6th or the 7th, in San Clemente. I met alone with him, and at that time indicated to him that I was going to appear before the United States Attorney and the grand jury, and I indicated to him that I was prepared to cooperate fully with the U.S. Attorney's Office and with the Select Committee, and that I would tell the absolute and full truth.
Now, did you had talked to him in California?
Yes, sir.
Did you ever have any knowledge that he was investigating this thing, whatever that is, for the president?
Well, sir, I think that my understanding was that he was conducting the investigation for the White House after Mr. Dean, the assignment for Mr. Dean was terminated.
Well, did you construe this statement that he said that they, the foreign evidence to the grand jury or the assistant district attorney who might be in the grand jury room, they'll ask you to whom you've spoken about your testimony. And I would appreciate it if you would say you've talked to me in California, because at that time I was investigating this thing for the president. Did you construe that to be a request that if you were asked who you talked to and you said that you talked to him, that you would say that you talked to him in California rather than on the day that this conversation occurred?
Yes, sir.
Yes. Now, on page 6, Ehrlichman says to you, they're out to get me and they're out to get Bob. And you say, my God, all right, well, John, it'll be absolutely clear that there was nothing looking towards any cover-up or anything. It was strictly for the humanitarian. And when I talked to you, I just wanted you to advise me that it was all right on that basis.
Yes, sir, that was my understanding.
Now, unfortunately, people, you know, I don't know whether in California you have lightning bugs, but we have them in North Carolina. And sometimes I wish that, the people not like lightning bugs. Lightning bugs carry their illumination behind them. But I would like to ask you if in retrospect, and with your illumination behind you instead of in front of you.
Yes, sir.
If you don't think that people could reasonably conclude that this money was paid to these defendants and their families to induce them to keep silent?
Yes, sir, I do. Now, again, in hindsight.
Now, I want to commend your testimony and commend your frankness. I'm glad I don't have quite as much faith as you reposed in certain individuals. Not referring to those individuals, but I haven't seen such faith in any human being since Bernard L. Barker testified about the faith he had in E. Howard Hunt. No,
Mr. Chairman, it's 5:25, and even though I have some other questions, I also have a highway conference at 5:30, trying to pick up a few stitches on other senatorial activities. I have one or two points that I'm going to leave with Mr. Thompson to try to clarify, and I'll only end by saying that I, too, thank you, Mr. Kalmbach, for coming. I have marked a great big mark for Senator Irvin and his lightning bugs. We've been blessed with a good bit of hindsight, but I want to especially thank you for your candid reply on the question of whether or not the institutional arrangements of the White House had some bearing on what did in fact happen, not in hindsight, but at the time. Because a year or 2 or 10 from now, this will be hindsight. And the purpose of this committee is to try to find ways to avoid this in the future rather than to pass judgment necessarily on what happened at the moment. So, Mr. Chairman, I'll leave my questions to Mr. Thompson, and I'll go now to that highway conference.
Thank you very much. Mr. Kalmbach, I've been listening to your testimony very intently. I just have a few questions for my personal clarification.
Yes, sir.
In your testimony, you indicated that someone pressed the, quote, green button, thereby putting into motion the Watergate burglary, something that you described as being idiotic, and I agree with you. It was idiotic and monumentally stupid. However idiotic, I gather from your testimony that you assumed that this burglary was carried out to benefit the re-election campaign of the President of the United States. Is my assumption correct, sir?
Yes, sir, I would agree with that.
Therefore, there existed this moral obligation.
I believe so, sir.
But however, you did not know as to the identity of the person who pressed the green button.
No, sir.
Now, when Mr. Dean directed you to raise these funds for humanitarian purposes and was later assured by Mr. Ehrlichman that Mr. Dean was authorized to ask you to risk your career and carry out this covert fundraising, you must have assumed that these men either participated in pressing the button or knew who pressed the button. Is that assumption correct, sir?
Yes, sir.
And without question, you obeyed the direction of Mr. Dean and Mr. Ehrlichman?
Without question.
Because you were certain that, as you said, they were trusted implicitly by the President of the United States?
Yes, sir, and trusted by me.
And that everything they did was done in the President's best interest?
Everything that was done, I know, was done in the President's best interest and in the best interest of the campaign.
I don't suppose you listened to Mr. Dean because you were convinced he was the button pusher or the mastermind.
I didn't understand that he was the button pusher. I think Mr. Dean had received the assignment to approach me, knowing whoever gave him the directions, Senator, knowing that I would trust Mr. Dean.
Now, in the hierarchy of influence and authority in the committee and in the White House, above Mr. Dean, you will find Mr. Ehrlichman. Isn't that correct, sir?
Yes, sir.
And above Mr. Ehrlichman, Mr. Haldeman.
Yes, sir.
And above Mr. Haldeman?
Yes, sir, the President.
I don't suppose you considered Mr. LaRue to be the mastermind.
No, sir. I think Mr. LaRue, again, was doing what had been requested of him.
I don't suppose you considered Mr. Ehrlichman to be the button pusher.
I didn't know, Senator. I just did not.
What did you think when Mr. Ehrlichman told you that Mr. Dean had authority? From whom?
I wasn't certain, Senator. I didn't know whether it was someone in authority at the committee to re-elect or someone in authority at the White House. I just did not know.
Was it possible that someone in the committee to re-elect could have ordered Mr. Ehrlichman to do something? Was there anyone greater in influence or authority in the committee?
No, Senator. No one could have ordered Mr. Ehrlichman to do anything, but
So it had to be either Mr. Ehrlichman, the button pusher, Mr. Haldeman, the button pusher, or someone higher than Mr. Haldeman.
Well, Senator, I think it could be someone in authority in the committee to re-elect, and Mr. Ehrlichman was advised of this, and Mr. Ehrlichman agreed that this was the proper thing to do. I don't know what went through his mind. I know that when I spoke to Mr. Ehrlichman, he told me that it was proper and to go forward, Herb, and without more, and that was good enough for me. But I do not know, Senator, I do not know whether Mr. Ehrlichman knew that it was someone in authority at the committee to re-elect or someone else.
And listening to your testimony, would I be correct to contend that it is your suggestion to the committee that your candidate for the button pusher is Mr. Ehrlichman?
No, sir. I don't have a candidate as the button pusher. I have the feeling, as I think I've expressed, Senator, that it was someone in authority at the committee to re-elect. But I don't know.
And my final question, sir. Throughout the testimony, you used certain words. For example, you were ordered by Mr. Dean. You were directed by Mr. Higbee. You were directed by Mr. LaRue to, for example, when Senator Talmadge questioned you, to distribute $400,000 to unknown persons.
Yes, sir.
And you didn't know for what purpose, and you didn't ask for what purpose.
That is correct.
Are you suggesting to this committee that in this assignment, your sole job was that of a messenger?
Yes, sir. That's really what it amounted to. This job as trustee was to act when I was requested to do so by Mr. Haldeman or one of his deputies.
Don't you feel that it was rather demeaning as a senior partner in a prestigious law firm to be used as a messenger by people like Dean and Haldeman and Ehrlichman?
Yes, sir.
I thank you very much, sir. Thank you very much, Mr. Chairman.
Mr. Kalmbach, what were your feelings upon learning that you were taped by Mr. Ehrlichman?
Senator, I can't describe the feelings. I think I've indicated before when I recognized that this whole program that I've been asked to get into, and which has made me feel like I'd been kicked in the stomach. Well, I can't describe to you, Senator, the feeling that I had when I learned that I'd been taped. It was just as if I'd been kicked in the stomach.
And when did you first learn that you'd been taped?
I first learned it when I before the U.S. Attorney.
And your feeling was, how have you described it, just as if you were kicked in the stomach?
Absolutely.
Would you feel the same way if you learned you were taped by the President of the United States?
Yes, sir, I would feel that way if I learned I'd been taped by anyone.
Now, just a couple of brief questions that I still am not clear in my own mind on the taped telephone conversation, the one that was taped by Mr. Ehrlichman. And let me put this in its proper context. As I gather in your response to the chairman's question, you feel this was a self-serving telephone conversation insofar as Mr. Ehrlichman is concerned. Is that correct?
Yes, sir, I would assume that.
Nevertheless, I do have to come back to that point on page 4, and it's repeated again back on page 6, where Ehrlichman says, I made no independent judgment. You say, yep, yep. And then Ehrlichman says, I'm sure Bob didn't either, and I imagine he's referring to Mr. Haldeman there.
Yes, sir.
And you say, nope. And I have the feeling, John, that I don't know if this is a weak read. Now, the chairman put his emphasis on the last portion of the statement, but I'd like to get to the beginning of that. I mean, how did you know that Bob Haldeman didn't have any independent judgment?
I didn't. I did not.
So why did you agree with Mr. Ehrlichman?
I just continued the conversation, Senator. That was it.
Well, again, back on page 6, again, he indicates that they're out to get me and they're out to get Bob, and you say, my God, all right, well, John will be absolutely clear that there was nothing looking towards any cover-up or anything. Now, again, I have to repeat my question. Did you have any direct knowledge that Mr. Haldeman had no knowledge of these matters?
I did not. I did not know really prior to this time that Mr. Haldeman had even known really of my involvement in the role that I played in this, Senator. As I think I've testified, throughout this entire time, up until when I spoke with Mr. Ehrlichman, who again had made the statement to me in California that he had been approached, he and Mr. Haldeman had been approached by Mr. Dean on this so that Mr. Dean would come to me, and then here in this taped conversation, that was the first time that I knew that Mr. Haldeman had any knowledge of my role.
Now, again, on page 4, could you give to me the meaning behind Mr. Ehrlichman's statement, yeah, I wouldn't haul the president into it if you can help it, and you replied, oh, no, I will not?
Of course, Senator, I did not know that the president had any knowledge in any way, shape, or form, either of the break-in or anything regarding this post-June 17th period.
Now then, one last question on the taped telephone conversation, and referring to page 6. You make the statement, do you feel, John, that calling it straight shot here, do you feel assured as you did when we were out there that there's no culpability here? Now, why did you ask that question?
Well,
I mean,
Senator,
do you think I'm correct in assuming that there are some real second thoughts arising here as a result of this conversation on your part?
No, sir. I wanted to be, when I talked to John Ehrlichman, California, he said, Herb, you have absolutely no culpability in this matter. And when at this meeting, he knew the complete situation, and I just wanted the assurance, because he knew exactly what he had told me and what the instructions I'd received from Mr. Dean.
Well, now, in the course of this, again, I repeat, you make the statement, do you feel, John, the calling it straight shot here, do you feel assured as you did when we were out there that there's no culpability here? Then in several instances, you indicate surprise in response to information that Mr. Ehrlichman gives you relative to what Mr. Dean is doing, et cetera. Did this phone conversation, did this shake you?
No, sir. The phone conversation that I had really was triggered when I was this conversation on this date of this taping was triggered when I was in the hotel room with Mr. O'Connor and my partner, Mr. DeMarco, and we had just learned that Mr. Dean had said that he would not be the scapegoat, and I wanted to be assured that that Mr. Dean would tell the whole story and the entire truth.
Mr. Ulasewicz, if I'm not mistaken, is on or was on your payroll. Is that correct?
I dispersed funds to Mr. Ulasewicz, Senator, but not firm funds. They were funds that I held under the trust.
In other words, in what is known as a lawyer's trustee account. Is that correct?
Yes, sir.
All right, then who supplied these funds?
Those were funds that had been entrusted to me by Mr. Stans on or about middle of January of 1969, Senator.
So that these trustee account funds were ones given to you by Mr. Stans, and they were used to go ahead and pay Mr. Ulasewicz. Is that correct?
That is correct.
All right. You know Mr. James Knapp?
Yes, sir.
Do you consider him to be a confidant, a friend of yours?
A very close friend of mine.
Have you ever told Mr. Knapp anything in the way of a relationship between you and Mr. Haldeman, the fact that possibly you might be being used by Mr. Haldeman? Did you ever converse with Mr. Knapp on this subject?
I think I've been, in recent times, I think that I've indicated that I feel that I was used.
That you were used?
Yes, sir.
Used by who?
Used by the people who knew that the true purpose of this assignment without my knowledge.
Now, I think we really have come past the point, and I want to commend you. I don't want to give any other impression than the fact that this is obviously a difficult situation for you, and I think you are honestly trying to respond to the questions of the committee. But the term "we" is wearing a little bit thin, and I refer specifically now to the conversation that you had with Mr. Knapp. Do you feel that you've been used by Mr. Haldeman in this matter?
Yes, sir.
You do. Do you feel you've been used by Mr. Ehrlichman?
Senator, if they had knowledge of the true, what has been alleged to be the true purpose of this, and did not advise me, then I think I was used.
Do you feel that you've been used by Mr. Ehrlichman? Within that response?
I do, sir.
Feel you've been used by Mr. Mitchell?
In that same context, yes, sir.
Feel you've been used by Mr. Dean?
Again, the same.
Is there any other individual? Now, I've mentioned four that you feel within the description that you gave in your response to me that would fit into this category.
Any other individual in authority who had knowledge would fit in this category.
Yeah. Do you have any other names aside from those four which I've mentioned?
I do not.
So that in effect that the "we" that you've referred to these are the individuals that you associate?
Well, I don't know if that would include Mr. Magruder. I'm not sure as to Deputy Director, whether or not he would be included in that or not. But again, if he had knowledge and he had been the one, well, then he would be included.
And do you believe that these 4 individuals had such knowledge?
I'm certain, of course, that Mr. Dean had that knowledge. Now, as far as I remember, I don't know as to the others for certain as to whether or not they did have the knowledge that this was for the purpose that Mr. Dean has stated.
I have no further questions, Mr. Chairman.
There's some discrepancy between, well, first, what date was it? The 29th of June, 1972, that you accepted this assignment originally?
Yes, sir.
There's some discrepancy between your testimony and that, Mr. Dean, as to where you met. He was under the impression you met either in the Mayflower Hotel or in the Mayflower coffee shop or the Statler Hilton. You are positive, however, that the meeting occurred in the front of the Hay Adams Hotel, and that you went out into the park and talked. All right.
Yes, sir. That's my best memory as to the first meeting was on the 29th in front of the Hay Adams, and then a meeting in the park.
But that was, you have no doubt about the matter, that it was on that day, wherever the meeting occurred, that Dean asked you to accept this assignment.
I have no doubt as to the date, which was the 29th of June.
And you accepted the assignment for the reasons you have stated and performed it for several weeks.
Yes, sir.
Then, as the time passed, you got misgivings about the wisdom or propriety of the assignment and refused to have anything further, to do anything further to carry it out.
Yes, sir.
And that occurred about August or September?
August and September.
Yes. Then, after several months after you had come to the conclusion that you wanted no further that you would not participate further in the carrying out this assignment, you were asked to come to a meeting in John Mitchell's office, at which John Mitchell, Fred LaRue, and Dean were present.
Yes, sir.
And Dean asked you, in the presence of the others, to re-accept this assignment to raise some more funds for this purpose, and you declined to do so.
Yes, sir.
Do you have any questions?
No, I have no further questions, Mr. Chairman.
No.
Mr. Chairman, I have 2 questions.
Okay.
Now, as you previously testified, the strongest motivation for this project was the desire to protect the President's position in the campaign. That's about right, isn't it?
My motivation was that I was asked by Mr. Dean, the counsel, and knowing that it was whatever was it was proper and in support of the campaign.
And he put it to you in that context, did he not?
He put it to me in the context that we want you to take on this very important assignment, Senator. Yes, sir.
Because he was concerned about what would happen to the President.
I don't recall that he said that, Senator.
Well, anyway, as a lawyer, didn't you stop to think that the assumption of a moral obligation to help the defendants would tend to bring closer to reality the triggering of the very thing you were trying to avoid, namely the implication that the President, the White House, or the CRP might have been involved?
No, sir.
As a lawyer, wouldn't you, did you stop to think that this might be the wiser course?
I beg your pardon, Senator.
Let me repeat the question. As a lawyer, didn't you stop to think that the assumption of a moral obligation to help the defendants would tend to bring closer to reality the triggering of the very thing you were trying to avoid?
No, sir.
As a lawyer, wouldn't it have been more prudent to stay clear away from the very clouds of complicity represented by the defendants, so as to avoid the implications that have followed because of what was done?
Absolutely, yes.
That's all, Mr. Chairman.
I want to thank you on behalf of the... Oh, excuse me.
Mr. Kalmbach, let me see if I can clear up in my own mind anyway just what was meant by this weak read statement on page 4 of the transcription of the telephone conversation. I'd like to read a little further than I think we've gone. Ehrlichman says, yeah, well, as far as propriety is concerned, I think we're both relying on Dean. You say, yep. He says, I made no independent judgment. You say, yep, yep. Ehrlichman says, and I'm sure Bob didn't either. And you say, nope. And I just have been feeling, John, that I don't know if this is a weak read, is it? And then he says, who, Dean? And then you say, no, I mean they're still going to say, well, Herb, you should have known. And then he says, I don't know how you could have, etc. By this weak read statement, were you referring back to the reliance upon Dean, or were you in effect changing the subject and worrying about what people might have thought about your judgment in the matter?
Yes.
Which one?
Yeah, the last.
The latter?
Yes, sir.
You, in effect, had changed the subject, and the weak read was what you thought might be raising some people's minds. In fairness to you, I think, Mr. Kalmbach, we might refer to 2 or 3 other statements which are consistent throughout this transcription. On page 2, in this general context of how you got involved and where you stood then, as I understand it, you did not know that this telephone conversation was being recorded.
Absolutely did not.
And Kalmbach says, and also that you knew that I was your friend and you knew that I was the president's attorney. You say that. He says, sure. And you say, never do anything improper, illegal, unethical, or whatever. And then on page 3, you again, as has been stated, say, God, if I can just make it plain, it was humanitarian and nothing else. And further down on page 3, you discuss it, and you say, and there was nothing illegal about it. And then on page 5 again, where Ehrlichman says, and the point being, here, without attempting to induce them to do a damn thing. And you say, absolutely not. And that was exactly right. Of course, we know that Ehrlichman knew the conversation was being taped, but you did not. Is that correct?
Yes, sir, that is correct.
And this represents your sentiments and feelings at the time on April 19th, and I assume that they represented your feelings during the period of June and July of 1972, and you became involved. Thank you, Mr. Kalmbach.
Sir.
Just one thing to suggest, Mr. Thompson's question. You stated that you never attempted to influence any of the defendants or their counsel to do anything. As a matter of fact, you had no personal contact with any of them, did you?
No, sir, I did not.
And so if anybody did try to influence him in any way, it was somebody other than you and without your knowledge.
That is correct.
Well, thank you very much on behalf of the committee. I'd like to put in the record a letter that the chairman sent to the president as pursuant to today's meeting. Thank you very much. Excuse me. Yes. Yeah. The committee, what is it? You're excused at this time. I understand you're willing to remain under the same subpoena and return for further testimony in the event the committee desires further testimony and gives you ample notice of the time and place.
Yes, sir, I do.
Thank you very much. The committee will stand in recess 10 o'clock tomorrow.
So ends the testimony of Herbert Kalmbach, once the president's personal lawyer, who now admits that the money he collected and dispersed for the Watergate defendants was in fact a payment for silence, although he insists that he didn't know that at the time. Ironically, the testimony turned today on the transcript of a secretly taped telephone conversation between Kalmbach and John Ehrlichman this April. That transcript was reviewed as the committee brings continuing pressure on the White House to release tapes of presidential meetings and telephone conversations relating to Watergate. The White House says the tapes are White House documents and promises a more complete statement on the topic later. Last week, the White House announced that turning over such documents would violate the doctrine of the separation of powers.
After today's hearings, Herbert Kalmbach's attorney, James O'Connor, talked briefly with reporters, including Impact correspondent Peter Kay. He was asked to evaluate how his client may be affected by the questioning.
Mr. Mitchell's attorney, when I questioned him along similar lines, and of course Mr. Mitchell is under indictment and your client is not, indicated that he thought these proceedings very much put your client and his client in legal jeopardy. Do you think this kind of questioning, should any action be brought against Mr. Kalmbach, would place him in such jeopardy?
Well, I would really hesitate to make a legal judgment of that. I would say, and I'm not saying this to curry favor because the proceedings have already gone behind us, but at the beginning of our relationship with the Senate committee, when we were being interviewed and examined with Mr. Dash, Mr. Lenzner, with all of the staff, Mr. Bellino, and with all of the senators, I must say that the proceedings have been fair to my client. Now, as you know, we are not potentially at this point, and I'm not speaking, certainly wouldn't be presumptuous enough to speak the minds of the Special Prosecutor's Office, but to this date we have not been advised that that Mr. Kalmbach will be indicted.
The debate over White House taped telephone conversations and meetings escalated a notch more today as the committee wrote the president to ask how the tapes could be released. That happened after committee questioning of Secret Service officials who have custody of the tapes was cut short by a letter from President Nixon to Treasury Secretary Schultz, technically the boss of the Secret Service, again invoking the doctrine of the separation of powers. Also this morning, Press Secretary Ron Ziegler said the tapes would be considered White House documents, apparently implying that they could not be released to the committee.
Two of our semi-regular outside experts watched today's session with us. John Kramer of the Georgetown University Law Center and Stephen Hess, former Nixon aide, now senior fellow at the Brookings Institution. Gentlemen, beginning with you, Mr. Hess, what did we learn from today?
Well, first there was the reading for the first time and unexpectedly of the transcript of the telephone conversation of April 19th between Mr. Ehrlichman and Mr. Kalmbach, and this seemed to create a moment of high drama and anticipated revelation. But in fact, this was never realized, and the ultimate history of this hearing will show that this was barely a footnote. Instead, I think today we were living through and acting out the aftermath of yesterday's major development, the existence of the White House tapes. Today's testimony by Kalmbach added very little to our knowledge of the Watergate cover-up. Kalmbach was just one more person who could not or did not choose to implicate the president personally. One more person who pleaded absolute trust as the motivation for his actions. Rather, this day was dominated by the offstage jockeying for possession of the key tapes. The president refused to allow the Secret Service agents to testify. The committee wrote to the White House requesting the tapes. So what was most interesting to me about this day was not what happened, but rather the setting of the scene for what may soon happen.
Do you agree with Stephen's analysis, John?
Well, I think we learned a little bit more than that. For example, on the struggle over the tapes, I think we learned that the committee understands that it is a matter of accommodation and not litigation. If time is of the essence, as it is in this case, otherwise they would have to go through a contempt procedure in the committee, in the Senate, and at 3 levels of courts that could last a year to 3 years. And they would before then long be scooped by Mr. Cox. So either the president accommodates or they will never get the tapes in time for these committee hearings. Secondly, I think we learned that the White House seems to be inhabited by a series of patsies who get set up by other people. Mr. Kalmbach seems to be the perfect patsy, taking orders, acting under directions, disturbing to me because it shows the lawyer as servant without any significant independent judgment, although Mr. Kalmbach did, in August, decide he was not going to make any payoffs anymore, although at that time he didn't know they were payoffs. Mr. Kalmbach seems to have inhabited an Alfred Hitchcock world, going to hotels in certain colored suits and making deliveries of $400,000, or I guess he only made part of a delivery. And also, you see a concept of a personal lawyer having no contact or very minimal contact with his client, which again is a rather unusual concept in lawyer-client relationships. And finally, I get the very upsetting feeling that everybody seems to be sandbagging everybody else in the White House. Everybody is setting everybody else up. Dean is jumping as the sandbags drop on him. And here in that tape conversation, you see Ehrlichman trying to set up Kalmbach really as a witness on behalf of Ehrlichman if Ehrlichman wants to use that tape later to relieve himself. I think you also see a disturbing indication that Ehrlichman is suborning perjury with respect to when Kalmbach, in fact, spoke to Ehrlichman. Ehrlichman says he wants to have Kalmbach testify that they spoke in California and not in Washington the day before the grand jury convened.
Of course, the element missing here is we do not know what Kalmbach testified before the grand jury. He was not asked if he was asked that specific question. Steve, let me ask you very quickly, do you think that above and beyond executive privilege problems, legal problems, that public pressure will eventually force the White House to cough up these tapes, or at least the pertinent parts of the tapes? How can it be resisted?
Well, I felt when the question was just papers and not tapes that ultimately we would have some sort of face-saving device. It would be a negotiation. They would each seek a way to satisfy the respective demands of two important branches of government. That is more pressing now that we know there exists evidence that, in fact, can end this whole thing, if you will. And so the pressures will be even greater for this sort of agreement, compromise, and certainly the actions of the Irvin Committee today were, as Senator Baker said, in the spirit of reconciliation. That was not a tough letter that was sent to the White House, and it was already limiting what they needed to relevant portions of the tape, and so forth. So I think this is going to be worked out.
So your prediction is then that it will be worked out, and all of America will eventually find out what's on those pertinent tapes, right?
Well, I hope that's more than a wish. That is a prediction at the moment.
Okay, and we will remember your name and the date that you made it. Thank you all very much. All right, now there are probably some blunt things that need to be said about these White House tapes and what a refusal to divulge their contents could mean. Up till now, there has been mostly indirect talk around the central issue, the guts of it all. Simply put, if the President finds a way to keep us, you and me and the rest of the American public, from finding out what was said to John Dean in the Oval Office on March 13, 1973, and on the other pertinent dates, the ball game could be over. All of this talk about executive privilege and separation of powers is great for the historians and political scientists, but it sounds phony out here in the real non-constitutional lawyer world, in my opinion. The simple fact is that a man named Dean says the President of the United States had knowledge of executive clemency offers and hush money payoffs for the Watergate conspirators. The President has denied it. But now we know, the whole world knows, that there probably exists a tape recording of that March 13 conversation, as well as others. At stake here are possible criminal actions by the President of the United States. So nuts to abstract precedents about separation of powers. We have a right to hear those tapes. If the President is clean, then we'll all know. If he's lied to us about it, then we'll find that out too, and then the course of history will run. But if the President refuses to let us ordinary, non-sophisticated types hear those tapes, there could always be a nasty presumption of guilt that would be grossly unfair to Mr. Nixon himself. It started yesterday, and it grew more today, and it could continue to grow and grow until it blows Mr. Nixon's house down one way or another. Until tomorrow night, for Robert McNeil and Peter Kay, I'm Jim Lara. Thank you and good night.
From Washington, you've been watching gavel-to-gavel videotape coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. This coverage is made possible by grants for special events coverage from the Corporation for Public Broadcasting and the Ford Foundation, and has been a production of NPAC, a division of the Greater Washington Educational Telecommunications Association.